Mic should be on, why not? Mic check.
Mic check.
Good.
All right. Good morning. Can you hear me?
If you go to the next slide, but here.
Oh, I'm not doing any slides.
Okay.
I have no slides. Good morning, everyone, and welcome to the 2025 Owner Symposium. I hope everyone enjoyed this morning's networking and that you were able to visit all of our sponsors in the exhibit area. My name is Cheryl Burns, and I'm the Chief HCV Officer for the Chicago Housing Authority. It is great to be with you all today. So many friendly faces, so many old friends, housing industry professionals, both in person and with us on live stream. You are all important partners in helping to support investment in our neighborhoods, preserving affordable housing, and building stronger communities. We truly appreciate you joining us today as we celebrate 16 years of education and networking. In addition to this great work, this great event, we've been working hard to streamline program processes, and I'm grateful to hear from some of you that you recognize those improvements, and we appreciate the feedback. We know that these make it easier for both property owners and tenants, as well as provide opportunities for you to learn, invest in your future, and expand your contributions to your community alongside your tenants and colleagues. During registration, several of you submitted questions regarding CHA's stability at this time. CHA's budget is balanced, and our overall fiscal position is solid. We recognize that we are operating in an era of uncertainty at the federal level. This applies to both the amount of funding that public housing authorities receive from the United States Department of Housing and Urban Development and the impact of potential policy changes on our operations. I want to assure you that our team is carefully monitoring the situation in Washington, D.C., and is prepared to make adjustments as needed in real time to ensure that we continue to meet our mission of creating and sustaining strong communities where seniors thrive and everyone can unlock their economic power. Also, many of you are aware, CHA has an ongoing CEO search. For that, you can expect an announcement as soon as a decision is made. Now, I'd like to go over a few housekeeping details before I welcome our first speaker for today. First, should you need assistance or have questions or comments at any point during the day, please visit the hospitality desk located right outside this room, or you can find many of the CHA staff who are stationed around the event space. You can't miss them. They're wearing "How Can I Help You" buttons. You can also connect with one of our owner outreach coordinators during the event. Shannon and Emilio. Is Shannon not in the room? I don't see her, but she's wearing striking green. You can't miss her. Or you can reach out via email at owneroutreach@thech.org. Finally, I want to thank all of the vendors who are here today for their support, especially our gold sponsors, Community Investment Corporation, or CIC, Lowe's Pro Services, Manage Chicago, and Chris, I saw you somewhere, thank you, and Yardi. If you haven't already, please make sure to visit them in the exhibit area or connect with them online. You can find links to their websites on the 2025 sponsors page at the CHAOwnersymposium.org. At this time, I have the pleasure of introducing Catherine Richards, CHA's Inspector General, who will provide a brief update on her office before we jump into our first session of the day, which is Fair Housing One-on-One. Please join me in welcoming Catherine Richards.
Good morning, everyone. It's good. I'll say it again. Good morning. Yeah, that's great. It's exciting. Okay. Thank you so much to Chief Burns for inviting me to help kick off the 16th annual Owner Symposium. It's a great honor and a good opportunity for me to share with you all what we do at the Office of the Inspector General. And as Chief Burns said, my name's Catherine Richards. I've been with the CHA for the last 4 years, and I'm a licensed attorney. I used to work with the City of Chicago Office of Inspector General. And what we do really is all of our work is to help protect the HCV program and the work that CHA does. HCV is a really wonderful program that helps fill that gap for need for housing. And so what we do is we investigate, audit, and inspect for fraud, waste, and abuse. So we're here to protect the program and the good work that everyone else is doing. So in terms of the overview of the office, we're an independent department body within the CHA, and we promote accountability and integrity. Our authority comes from the Board of Commissioners and a charter that they approved, and that charter gives us the authority to conduct those investigations and audits. The jurisdiction extends to all officers, commissioners, employees, contractors, vendors, and programs for the CHA. And in that charter, all of those folks, anyone essentially receiving money from the CHA, has a duty to cooperate with the OIG in an investigation. That also includes a duty to report misconduct. So, we're all in this together. If you see anything that seems suspicious or concerning, we have a hotline, we have email, anonymous complaint portal. We'll take it all, and we can trust us to filter it out, right? We can refer it to the right department, but if you're concerned, please feel free. And retaliation is strictly prohibited, so anyone who reports misconduct or participates and cooperates in our investigations is protected from retaliation. So we're going to focus on investigations this morning. Our office conducts both criminal and administrative. The vast majority of the complaints that we get are referred over for administrative action by the HCV enforcement team. Just program violations. An administrative investigation involves a review of possible violations for the administrative plan or the CHA ethics policy, and potential outcomes for an administrative case would involve termination of the voucher. For vendors, it would be a potential suspension, abatement of the HAP payments. We can recoup overpayments in certain instances. And then for contractors, debarment. And that's something that as a government entity, CHA is supposed to only be doing business with reliable vendors to protect the public fisc, right? In the criminal case, in investigations, we are looking at the egregious cases. So we have a number of instances where a voucher holder may sign false documents, and that's fraud essentially if it's to your benefit, and it over 10 years. And how much are the vouchers worth these days? Thousands of dollars. So that adds up. And in those cases, we will gather the evidence and work with local law enforcement. So FBI, HUD OIG, Chicago Police, and we'll present that evidence to the Attorney General's office, State's Attorney's office, and in certain instances, the federal U.S. Attorney's office. So, our office has had a number of convictions. Those criminal cases involve cases of forgery, and in Illinois, it's a broad definition of forgery. So anytime you sign something that says is false and used to defraud somebody, that counts as forgery. Theft of government funds and wire fraud, because we're sending everything through the wires, essentially the email. And we're proud to say that we seek restitution. So we're trying to get that money back to help other people. Trends that we're seeing in violations of the program that really do escalate up to the level of criminal fraud are renting to a relative. Quite often that's collusion, essentially, where you can't rent to your son or your daughter or your husband, for instance, who you haven't disclosed. If there's collusion sometimes where the landlord and tenant may be splitting the money. The landlord may know that the tenant is subleasing and then monetizing the voucher for their own benefit. We've seen quite a few cases lately of voucher holders who own residential real estate. And so they get married, they buy a house in the suburbs, and then they sublet the apartment. So just, these are things to be aware of. On the more rare side, we see sale of fake voucher forms, and we'll talk about that in a minute. And some of this involves mortgage fraud, where vendors may be, they'll get a voucher, they'll legitimately go through the voucher process, and then not make any repairs to the unit and not pay their mortgage, and they're just and then sell it for a profit if the market continues to go up. So that can constitute mortgage fraud at times. So I'm just going to give a quick overview of a few recent investigations that have resulted in criminal charges. This one is pending right now in criminal court, and we're headed toward a trial in December. So People of Illinois versus Gwendolyn Martin and Lawrence Amos. These folks, Martin is the tenant, Amos is the landlord. Amos is also Martin's son. And when she got the voucher, Martin concealed her ownership of another residential property, right? So she was already a landlord when she got her voucher. And so when she finally gets the lottery and gets her voucher, she sets up her son as the management agent, right? So owners can submit management agent forms directing payments to someone else, essentially. So in that case, they forged the CHA documents by listing her son as the manager and directed the HAP straight to his bank account, which she also had access to, $158,000 over years. The interesting part about this was that they would rent apartments and never tell the landlord that she had a voucher. So these were landlords out on the private market, didn't know anything about CHA, but then she was also a terrible tenant, so they'd have to evict her. She wouldn't even pay the rent. So they had no problem testifying for us, right? But yeah, when they found out she had a voucher and was directing money that would have gone to the landlord, they were happy to help. So that was an interesting one. It's pending. Similar situation with People v. Robbins. Miss Robbins had permission to serve as the landlord for her mother. This was some years back, but because her mother was disabled, she had a power of attorney for her mother, could sign documents for her mother. And she continued to submit false recertifications for 9 years when her mother was in fact living in a nursing home. And 2 years after her mother died. So she was able to sign the forms for her. So that she pleaded guilty. That's very easy to prove, right? We've got the bills from the nursing home, the death certificate. When we find out, you're going to, be held to account. So that's a class 1 felony. She was older, so she's been given probation, but has ordered to pay full restitution, $110,000. And the last one is a similar situation. Let's see, husband and wife. Yeah, they're also landlords, sharing the money. The money just goes straight back to the tenant. You get the picture. It's over almost $200,000. Name and address discrepancies between the IDs. We have seen people who have a state ID and also an Illinois driver's license, and they have different addresses, different names, different dates of birth. So just things to be aware of in the back of your mind. If sometimes people use PO boxes as a way to conceal where they're actually living, if they've abandoned the unit, subleasing it. So we always ask for an actual address, in addition to the PO box. Any indications of undisclosed income, and this happens especially when people submit 0 income affidavits. They're required to report their income within 30 days if they suddenly hopefully get a job or get more income. But sometimes folks don't, and then they go a year or 2 years, and you might see a fancy car parked in the driveway. The indications that we need to know about. Unauthorized occupants, obviously, that affects the income calculation. So if someone's successful brother moves in, they're now part of the household, and more often it'll be a spouse. And we're happy for you. just let us know. And then obviously red flags that you call the OIG immediately if anybody offers you money, gifts from an inspector, or landlords and tenants are not supposed to also have side deals in addition to the CHA lease, right? So gifts, money, promises, please call us immediately. A recent scheme that we've identified is fraudsters who are selling forged voucher documents to apartment seekers, and this did actually catch a couple landlords. They believe these folks had a voucher, but then some months into the lease, they're like, well, where's the HAP? And I think they weren't quite as familiar with CHA processes, but those folks did not have a real voucher. So if someone comes to you with documents that look a little funny, please call CHA and just verify the tenant ID or the voucher. You will never, if you're getting a legitimate email from the CHA, it will be coming from @thecha.org or chacontractor.org. We've seen things like Jenny from the CHA@gmail.com, right? And it catches people. So just be aware. My other just general individual fraud prevention tips: protect your email and Rent Cafe passwords. We've had folks get scammed that way as well. Someone had their password with Rent Cafe compromised and money directed to the wrong account. Read what you sign. Your signature binds you, and it can hold you to things. Avoid sending checks in the mail. That is key. Lately, people seem to be extra good at washing the ink right off of them. I like to recommend signing up for the U.S. Postal Service informed delivery. They will send you a digital image of the mail that should be coming to your house every morning. And so if somehow it doesn't reach your mailbox, you will have a record of that. Review your account statements, make your Venmo transactions private. I don't know if anyone uses Venmo, you can see, I'm on there and I see that my cousin paid his landlord or his roommate for pizza. It's just strange. You shouldn't have that information. Don't be broadcasting it, right? And then in internet crimes, if you're getting strange emails, solicitations, and hackers, you can report them to the Internet Crimes Complaint Center. So that's ic3.gov. That's the FBI. And they do respond. They ask that you report these things immediately. If you've actually lost money, they can sometimes get it back. So it's a really important tool. And our website, the link for our information is at the very bottom of the CHA page. And once you click through there, you can read all of our reports. We summarize all our investigations and audits. Those are all on the website, and that's where all our contact information is as well. So there is a web portal where you can remain anonymous. So please feel free to call me directly, or just put in a complaint or concern. So that's the end of my presentation, but I'm going to open it up for a few questions. 5 minutes Q&A. We have microphones, and so if you have a question, please raise your hand so that folks online can hear you.
Hi, good morning. My name is Steve Nomura. I reported many cases that voucher holders has enough income, like 7,000, 8,000. Still, they have vouchers. Okay, I always asking why, and almost 100% they're hiding the income. But when they talk to the landlord like me, they disclose how much they're making. Okay, I reported to CHA many times, every time, maybe once, twice a month. But what I got the response like this: you have to find the voucher number, otherwise they can't do anything. Okay, therefore, I try to find out that kind of things can be, solved as soon as possible. But what's the solution of this? We have to find out the voucher number. Well, I gave an email address, telephone number, the name of the voucher holders. I think that is enough, right?
Yes, that would be enough. Honestly, I think if you report that over, at that point, the income recalculation will be between the voucher holder and CHA. So you may not know what's happening behind the scenes in terms of how long it would take for that process to go forward. But, feel free to call and ask and keep that communication open.
Hi, my name is George. We have an instance now, what we had before, that the tenant is actually, we know for sure he's not living at the unit. And then we approached them several times. We approached you guys several times.
Okay.
And my question is that beyond enforce your lease, what can CHA do in this case? Can they just maybe offer us a phone call to the tenant to intimidate them some way, some form? Because we invested time, money, and efforts to get this unit ready for the CHA inspections every year or every other year, depending on where we stand with CHA. Enforcing the lease, to say frankly, it takes about 6 to 8 months to evict somebody, and based on a 10-day notice for non-compliance and violation of the lease contract, usually it's basically left at courts nowadays, so you cannot really evict them. So what can CHA offer in this case besides telling me to enforce my lease? Because that's obviously is not a feasible route for us to do.
That's a great question. I'm going to have to defer it to the program team from HCV.
So what is the exact question?
So he's saying if the tenant has already vacated the unit, was that,
So their
oh,
son
someone
lives
else
there
lives there.
illegally, basically. Also, they are very bad tenants. They are
Okay.
disturbing the others.
So, am I on? Can you hear me?
I don't think so.
So if the tenant has vacated the unit, and you're the owner of the property? Okay, so typically, I'm very confused at that situation, why anyone would tell you to enforce your lease. They need to report that, you should report it to us. We can verify by scheduling an emergency inspection, trying to get access to that unit to see if the family is there. You're not gonna like my next answer. We would stop the HAP. If the family has vacated the property, the HAP contract automatically terminates. So you would need to enforce the lease to be able to legally get rid of their items in the unit. But if we find out that tenant's not in the unit, we're gonna terminate the HAP. I know that owners like to CHA to call and make a threatening phone call, but we can't physically make people do anything. So the most we would do is enforce from our perspective, which would be to terminate that voucher holder. They would have an opportunity for a hearing, and it would go through the regular process. But we should at least be able to inspect that unit and verify whether the participant is there or not.
Thanks, Cheryl.
Question right there. I want to add to similar situation regarding this gentleman mentioned. And this is current as well, within the last month or so. There was a tenant, it goes back as far as April of this year. The HAP contract was then abated due to noncompliance on our end. The tenant then, currently to this day, residing in the unit. Now, to add to that, they submitted RTA papers for a whole nother location, passed it, everything. Chose to continue to stay in my unit, moved other people in with a dog. I reported this to CHA, sent several emails. One person, I won't mention their name, responded to the email simply, we're reviewing your case, thank you. Another one responded. I said, okay, well, you obviously didn't read my email. So I forwarded back to him, saying, you didn't read my email. This is what and I got more specific. Hey, he's living there. He has a dog. Blah, blah, blah. His response was, oh, after review, I see that the HAP contract was abated and blah, blah, blah. You have to enforce your lease. Wait a minute. Again, it was abated. He got approved at another apartment. The reason why he hasn't moved, this is going to kill you guys. He didn't have a move-in fee. After further investigation through my maintenance staff and other tenants, the moving fee was $1,200. He went through some program, got $900 of the $1,200 for the moving fee. I was so sick of him. I said, I'll give you the other $3. Just get the hell out of my unit. Just go. He took the $900, blew that, you guys, and he's still in my unit. And you all's response, enforce your lease, and I quote. To this day, as we speak, still in my unit, with the dog and others. And I need to enforce my lease.
Can I speak?
We'll take this gentleman here.
Okay, I guess I'm a property owner and I have a similar question and situation. So if a tenant moves in, an unauthorized occupant, how do we remove them or how do we expedite that process of getting that unauthorized person out or getting that tenant and the unauthorized person out?
So at that level, these are the day-to-day program management questions. I think an unauthorized occupant, you're gonna have to just have a conversation with your tenant, right? And it is that kind of management between a landlord and a tenant.
But they're in violation of the HAP contract though.
True. True. And then you can report it to us as well if after you've talked to them, right? It's like they should have a chance to correct the problem before they call. I mean, I hear you. I
Okay,
hear
usually
you.
when you give them that chance, they still don't comply, so,
And then you can,
okay. Okay, well,
no, we have
thank
no
you.
more microphones here, but
You got a question here.
Okay, and kind of related to that, when it comes to criminal activity,
yeah.
and I'll give you an example. Say, for instance, there's an older person, maybe even an elderly person, and they have a child or a grandchild who is engaging in criminal activity, maybe outside of the building or in the neighborhood. Can the voucher holder be held responsible for that, or can somebody report them saying like, "Hey, this person is terrorizing the neighborhood, and he lives with this person who is a voucher holder." He or she, sorry.
Yeah. Again, these are all program questions that I really am not the best person to answer them, but I would say typically it's conduct in the property, right? So again, it goes back to the contract you have with the tenant, the lease. And you can always call CPD, right?
Catherine, can I?
Yeah.
Um,
Please.
so there is a session later in the day called Ask CHA. These are more questions for that session. What Catherine is here, she's talking about how to root out fraud and how to report to our Office of Inspector General. So if there's no questions regarding rooting out fraud, I feel like we got a hand back there. But otherwise, those questions you can ask the staff either in the area outside, which I mentioned to you, or during that Ask CHA session later on this afternoon.
So we got a question right here.
It's not fraud that's handled by the OIG. So they do investigations where they will send people to get criminal judgments. So they are working with law enforcement to chase down things like wire fraud, theft. They're stealing money from a federal program. So those are the types of things. When you're talking about a HAP contract violation, the HCV staff are here to kind of handle those questions for you.
And thank you, Cheryl. That is, it's true. It's a fine line. It's a nuance, but before it gets up to the level of a criminal prosecution, so people who are breaking the rules, that's going to happen routinely. But we have to correct them, give them chances. After a while, if they've been lying repeatedly over years and it's egregious, that's when it comes to our office, really. Should we take one more question? Oh, up top?
My question is real simple. Where do you do the internet crimes reporting? You had
Where-
named the site. Repeat your question.
Where do you do it? It's the ic3.gov. Yep. Okay.
I noticed that you said there were only 3 or 4 that was put on the screen up here, but there's hundreds of thousands of these cases that are not taken through the court system. And I want to know what our current president is coming down on CHA and trying to find more fraud cases throughout CHA. Can you say anything about if there's any been revisions on finding more fraud cases? Because it seems that the few that you've listed here are so minimal compared to what probably is really out there.
Well, thank you for that. I'm not going to speak to the current administration or any changes, but as far as the work that we're doing, it hasn't changed. I think we're at the same volume, our same partners, still at the U.S. Attorney's Office, still at HUD OIG, Illinois Attorney General's Office. I mean, I think we saw the very severe reduction in force at the federal level. So there's fewer HUD OIG agents, there are fewer FBI and US attorneys. But everyone we've dealt with so far has still had the same values and the same intent to protect the CHA from fraud. And it's true, every program violation cannot possibly go through the court system. I mean, it's like a week of my time, a week of an investigator's time, a prosecutor. We don't want that, right? And we don't want every violation to be someone in jail, because then we're housing them that way, right? So we're trying to just appropriately address the fraud and the abuse of the program to the best of our ability. I don't know if we're out of time, I think, for my session. So thank you, everybody. And then I'm going to hand it over to our next presenter. Please welcome Deputy Chief of Fair Housing and Policy, Kimberly Nevels. Thanks.
All right. Thank you, Catherine. That was great information. As Catherine mentioned, my name is Kim Nevels, and I am the Deputy Chief of Fair Housing and Policy for CHA. Chief Burns is who I report to. So it's a pleasure to be here with you today, and I appreciate you all for joining us for Fair Housing 101. As a reminder, if you have a CHA or personal account related question, please visit the hospitality desk. It is right outside this room. You can also connect with the owner outreach team via email at owneroutreach@thecha.org. owneroutreach@thecha.org. And they're going to be happy to help. All right, here we go. All right, so I'm going to be talking about fair housing laws, reasonable accommodations, source of income discrimination, the other protected classes, advertising, some case studies, and Q&A. And as time allows, because I know I'm the one between y'all and lunch, we'll see how long, some of these sections last, okay? All right, so we have the Federal Fair Housing Act. It covers most of the housing in the US. And we also have the Illinois Human Rights Act, which covers most of the housing in Illinois. The enforcement agency for the Illinois law is the Illinois Department of Human Rights and the Illinois Human Rights Commission. We also have local laws. We've got the Chicago Fair Housing Ordinance, which covers nearly all of the housing in the city of Chicago. That enforcement agency is the City of Chicago Commission on Human Relations. We've got the Cook County Human Rights Ordinance, and that covers most of the housing in Cook County. That enforcement agency is the Cook County Commission on Human Rights. All right, so when you look at all of the protected classes that are listed under the federal law, under the Illinois law, under the county, under the city, you've got a lot, right? So big ones: race, color, national origin, disability, ancestry, religion, familial status. Familial status is families who are pregnant and families with children under the age of 18, all right? We've got age, which is, unlike the families with children, 40 and up. We've got, I've got ancestry on here because I was dealing with multiple laws. We've got sex, gender identity, pregnancy, marital status, housing status, sexual orientation, military status, unfavorable military discharge. We've got criminal history. We've got source of income. So obviously there are a lot of ways that people can be protected under all of the different fair housing laws, right? So all of this is available online under Google. It's out there, all right? Don't need to memorize them. All right, who's covered? So real estate owners are covered. Property managers are covered. Salespersons, brokers, rental agencies, other agents, the employees of the owner or the owner's agents. All right, you've got builders, you've got appraisers. So almost anyone who has anything to do with the real estate industry, the rental, the sale of property, they are covered in any number of ways. All right. and they are responsible for making sure they don't violate the laws. So the different types of real estate that are covered: houses, apartments, condos, mobile home parks, vacant land in some instances, and any other type of residential property. So, for example, long-term stays, hotels can be covered in some instances. All right, here are some examples of prohibited activities. Refusing to engage in a real estate transaction. All right, so someone comes and they want to rent, and for whatever reason, they are denied, even though, for example, that rental unit stays on the market. So that's an example. Refusing to receive or transmit a bona fide offer. Misrepresenting the availability of property for inspections, for rent, or for sale, when in fact that property is available. Failing to disclose actual property listings. Expressing orally or in writing an intent to engage in unlawful discrimination, either directly or indirectly. All right, that's a lot, I know. So big ones though that a lot of folks are dealing with are reasonable accommodations. All right, so I tend to start with definitions. So the definition of disability under the Fair Housing Act. All right, so the Fair Housing Act defines disability as a physical or mental impairment that substantially limits one or more major life activities, having a record of such an impairment, or being regarded as having such an impairment. And so some of y'all may be like, what do you mean when you are regarded as having that impairment as opposed to having the record, right? Folks who deal with property, I'm sure that there are many people who you have encountered who may deny that they have a mental health disability, right? They are adamant that they do not have a disability, but in dealing with them, they are regarded as having such, right? So that's what that means, where they may not have the paperwork, but they are absolutely regarded. There are some people who have some physical limitations, right? For whatever reasons, but they don't want to acknowledge that limitation is an actual disability, but they are regarded as having such. All right? Okay. So major life activities, this is not an inclusive list, such as learning, breathing. I'm asthmatic, sometimes it's hard. Walking, caring for oneself, right? So limitations, and there are lots of limitations. Some of them are absolutely apparent. Some of them are invisible disabilities, right? So that's where we go, but they interfere with major life activities. Like I said, these disabilities can be apparent or hidden. And again, we have a number of laws. So the ADA, the American with Disabilities Act, I went through the other ones, Illinois, Cook County, Chicago, all of these definitions of disability are consistent. All right, so what's the definition of reasonable accommodation? A reasonable accommodation is a change, an exception, or an adjustment to a program, service, or procedure that allows a person with a disability equal enjoyment of housing. So a common one that comes up is, so say rent is due on the 1st of the month, but that person's disability check doesn't come till the 5th of the month. So reasonable accommodation in that policy is providing that person the opportunity to pay their rent on the 5th. All right. All right, so we've got examples of disability discrimination. Absolute outright refusal to rent to people with disabilities. Discriminating in rental terms or conditions. An example of that is, and that I've seen in some instances, is where they say that, oh, you're disabled, you need to show proof of more insurance because we're worried that you're going to fall. That's a discrimination in a term and condition. You wouldn't ask that of another tenant, right? refusing to rent to a person who is blind, to a hearing impaired person, to a person who uses a guide, hearing, or support animal, charging extra for that service or support animal. Failure to make a reasonable accommodation. Oh, wow. Failure to make that accommodation in the rules, policies, practices, and services so that these people can have the equal opportunity of housing enjoyment. I guess y'all can see it better now. Okay. Now I can't see you though. All right, so property owners must consider reasonable accommodation requests from their tenants with disabilities. So those requests can come in verbally. Some people prefer to have a record of it. It can be in writing, email, et cetera, et cetera. The law requires a property owner to grant those tenants with disabilities that accommodation, and there are only two exceptions. All right. Those two exceptions are if accommodating that particular request would fundamentally alter the nature of the program, the nature of your operations, or if it would create an undue financial and administrative burden. So those are the only two exceptions. And at that point, it is incumbent upon the property owner to make the case that it is an undue financial or administrative burden, or that it would fundamentally alter the program. All right, so one that comes up a lot here at CHA is live-in aids. All right, so the HUD definition of a live-in aid is a person who resides with one or more elderly persons or near elderly persons or persons with disabilities who is determined to be essential to the care and well-being of that person. They are not actually obligated to provide support of that person. So as an example, I am obligated to take care of my husband, but would not be living in the unit except to provide those necessary supportive services. Okay? All right, another big one is source of income discrimination. All right, in January 2023, the Illinois Human Rights Act expanded to provide protection against discrimination related to source of income in housing and real estate transactions. All right, it prohibits discrimination against a person based on their source of income when renting an apartment or receiving housing related services. The act also prohibits real estate brokers and appraisers from discriminating against a person based on their source of income. All right, and so here are a number, and like I said, I've got allergies, so apologize. So based on the source of income, here are your examples. We've got income from employment. We've got housing choice vouchers. We've got federal, state, local, there could be private housing assistance. There's emergency housing assistance payments. Might get alimony, spousal support, retirement income, veterans benefits, Social Security, so retirement benefits from Social Security, so supplemental income, SSI, or Social Security disability. So lots of examples of source of income. All right, so here are a few examples of violations of the law based on source of income. So after the act was passed, I didn't see as many of these in the paper, or online, I guess I should say. I'm old, the paper. Making any statements or written communication such as no Section 8, no Section 8 approved, not set up for Section 8. All right, refusing to rent to an otherwise qualified person because that person would use a voucher to rent. Refusing to cooperate with the administrative requirements of the voucher program, completing the routine paperwork, allowing the inspection of the property, or engaging in different treatments in the price, the terms and conditions, or the privileges of tenancy based on use of a voucher or any other source of income. So my example for this is not here in Chicago, it is in New York City. So in New York City, before they outlawed it, there were some buildings that actually had pour doors. That is exactly what they called it. So you could go into the main lobby entrance if you were renting on the private market, but if you had any type of voucher or housing assistance, they actually had a poor door. They actually had, you could not utilize the amenities of the building, such as the rooftop deck, right? You couldn't use the pool. So that is what I'm talking about when I say that you cannot discriminate in the terms and conditions based on the use of the voucher, all right? It's just a good example. So this is a big one, minimum income standards, right? So you've put your unit on the market, and in the private market, you're saying this person needs 2 or 3 times income to qualify for the unit, right? However, they have a voucher. So the voucher is going to cover a good portion of that rent. So math is not my strong suit, so I like these easy numbers, right? So say the unit is going to be rented for $2,000. So the minimum income requirement is 2 times the rental amount. So the participant has a housing choice voucher that's going to cover $1,800. So you don't have to worry about $1,800 of it because CHA is covering $1,800, right? So you need to look at the $200. So if you're looking at the tenant portion, they need to show income of about $400. If it's 2, $600 if it's 3. All right? We'll get questions later. I'm sorry, I should have said that first. Hold on to your question, please. But this is an example. All right. So what constitutes discrimination? Again, making discriminatory statements or publishing those discriminatory communications. Again, refusing to complete the paperwork, to process the offer, or again, refusing to allow them to come in and do the inspection. Requiring the 3 times the total rent. So that was the example I was giving. So you're not going to look at the total rent, you're going to look at the tenant's portion, right? Steering applicants to a particular property or area based on their protected class. So I've worked in this area a long time. There have been buildings where literally it was like they steered the families with children. That was the building for the families with children. The other building was for families without children. That is also against the law. All right. Charging additional fees, restricting access to the amenities, to the common areas, charging standard lease terms based on, and charging more, I should have said, based on the tenant's protected class. All right. All right. So we got through the big ones. All right. But y'all remember that list. There's a lot. Okay. So examples of others are family status and pregnancy discrimination. So I've seen ads that they literally said, no children, no dogs. So that's against the law, right? It is also, I've seen instances where people have, limited access. So say there's a pool and saying that, the kids are not allowed to swim. That's discrimination. Inserting lease provisions that call for termination of the lease if children come to live in the household. Families are made up of all kinds, right? You've got grandparents raising grandchildren. You got aunties taking in play cousins. I mean, families are made up a lot. So, we cannot discriminate against families with children. Discriminating against people who are pregnant or people who are in the process of adopting or securing legal custody of the child. Limiting the number of children under age 18 as opposed to the total occupants of the unit. All right. So again, I talked about steering. You can't have certain floors. You can't have certain buildings that are only for families with children. Applying different policies or different rules to families with children. They're expensive enough. All right, national origin. National origin is the place in which a person or one of his or her ancestors were born. So being of a particular national origin means that that person has or may be perceived to have physical, cultural, or linguistic characteristics of a particular national origin group. And so property owners of an example of national origin discrimination, property owners of one national origin group would only rent to people of that same national origin. All right, so that's the example. All right, immigration status. So if you're going to inquire about immigration status of one group based on how they are perceived, you should ask it of everyone. All right. It's illegal to require more documentation or fees to rent to an immigrant. And if a prospective tenant brings along an interpreter, the property owner, manager, or agent, they must work with them. Especially for language barriers, it is no different than if someone is deaf and brings along an ASL interpreter. All right. All right, so we've got the Cook County Just Housing Amendment, which established a 3-year threshold for criminal history when screening a protective tenant to rent a unit. So 3 years is the limit, so they cannot consider criminal history that is more than 3 years old. And this is where it comes in, must conduct an individualized, say that 3 times fast, individualized assessment of any applicant with criminal history less than 3 years old. So you just can't just make a blanket statement saying that, oh, you've got criminal history, it's recent. You have to do an individual assessment regarding that criminal history, okay? Questions later. Hold on to it. Hold on to it, sir. Okay, because you're going to need the mic. That's why, so that people can hear. But thank you. All right, we've also got the Violence Against Women Act, which is a federal law that protects victims of domestic violence, dating violence, sexual assault, stalking, who apply for or live in private housing with a voucher. So those protections extend to the entire household regardless of gender. So protections include removing the abuser from the voucher, issuance of emergency moving papers. We've got the Illinois Safe Homes Act, which also offers protection to victims regarding lease termination, changing locks. And so another website for y'all, the cha.org/VAWA for more information. All right. So we've talked a lot about advertising and statements. So the law prohibits making, printing, or publishing ads that indicate a preference, limitation, or discrimination based on a protected class. That whole long list again. So the law applies to any person who places that ad. So property owner, the home seller, a realtor, the lender, and the advertising agency that may prepare the ad. All right. So obviously there's some best practices. So the content of the ad should describe the property, not the potential or the preferred tenant. Right? So avoid words or symbols or adjectives that would suggest such a preference. So include the fair housing logo, include a statement. And so one of those is like the ones I've seen where people have complained and filed cases is like quiet building preferred, so you're talking about the tenant or you're talking about your prospective tenant, what you prefer, as opposed to describing the property, right? Elderly, seniors preferred, and it's not a senior building, right? So don't do it. All right, so we're getting close to questions, so hold on to them. All right, so here are a couple of examples. So property advertises that he or she is seeking a quiet, mature resident. And so if you think that that owner is violating fair housing, raise your hand. All right, most of y'all. So looking for someone who is quiet or mature is often coded for no children. All right. And so property owners shouldn't use this to describe the type of person that they want, describe the amenities of the property when advertising a unit. All right. Property owner only shows an older single woman a unit on the ground floor level when there's availability on the second floor. Is this a violation? Raise your hand. Not as many raising your hand. This is actually, yes, this is steering. So this is steering based on perception of age, possibly any other protected class. Maybe they may think that that person is single. Maybe they perceive that person as being disabled, right? So since you're concerned for this person's safety, so we're gonna say that this was good intent. We're not going to put ill intent out there, right? But that the perception was that the lower floor would have been safer for an elderly person. All right. Okay, so that's the end. I'm Kim again. You can find us at Fair Housing at thecha.org. And this is our number. And this is a good time for questions. All right, so it's going to open up for Q&A. Raise your hand so that some of the volunteers can give y'all the mic so that the people who are streaming it can listen. Okay? Oh wow.
Hey Kim, I got a quick one. Thank you so much for the
Okay,
information.
sorry.
Can you hear me? Thank
Yep.
you so much for the information. The content is fantastic. Two really quick ones. You mentioned service pets and animals. A lot of people will just have a pet come in and claim support. Is there any specific qualifications that are needed for a service animal or support pet? That's one. And then a second one, protected classes of income. Insurance is our toughest part of the business now. Insurance companies are asking us, is Section 8 living in the building? And we are being denied in some cases from insurance companies. So I know that wasn't mentioned, but is there anything written regarding insurance companies discriminating against owners who are leasing to voucher holders?
Okay, let me take the first one. So if a person has a disability and they have requested a reasonable accommodation, and that reasonable accommodation in your policy, so for example, you have a no pet building, right? So bringing in a service animal, bringing in an emotional support animal is an accommodation for that person's disability. Yes, you are absolutely able to request medical verification. So they should make that reasonable accommodation request that they have a disability, that they require this emotional support animal. I've seen so many of these cases, for example, because it's not an apparent disability. People with depression are often prescribed an animal because it helps them, get up in the morning. It helps them go for a walk. Exactly. Thank you. So that's common. However, it's an accommodation. So yes, you can require and request medical verification. All right. The only dogs that are certified are like guide dogs. So a lot of times the animal's not going to be certified, but they're going to be able to, they should be able to prove that they are disabled. And as far as the insurance question, so that's an interesting one because honestly, that's a bigger case. I would be taking that to the state because that is absolutely discrimination and actually, I'm a lawyer, prima facie, on its face, it is discrimination that that they are requiring more money for a voucher holder as opposed to a market rate tenant. That is how that law is laid out. I'd be talking to the Illinois State Attorney General and the Illinois Department of Human Rights. Good case. Thank you.
I saw that you can't discriminate against somebody's housing status, but you didn't really go into detail.
For example, unhoused. So there's a person who is homeless and they don't currently have an address to use. And so it's going to be much more difficult for that person to provide rental history. They may not have the documentation. So that's an example of
So
housing
if
status.
I got a potential tenant and I visit their home and I find out that they have some non-paying house guests and I decide not to rent to them, I'm not discriminating them. By what I mean by non-paying house guests, it's the creepy crawly ones.
Oh, okay. So see, that's a question for the property, because I'm like, that's really not my area of expertise about housekeeping. I know what you're talking about, but all right.
My question is, you were making reference to the 2 times the amount. So is that the law now, only 2 times?
No, so there's no law regarding there's
Okay.
no law regarding minimum income. I just know that when people like are getting tenants and that is like a requirement to rent, is that you have to show 2 or 3 times the rate of the rent. And so, in that example, if here I am, as a private market renter and that unit's 2,000, they want me to prove that I've got at least $4,000 of income, right? And that's where I'm like, that's not the law. It's just what people are using to screen tenants. And that's where I'm saying if you do it it could be source of income discrimination to then go to a voucher holder and provide and ask them to do that same thing. They wouldn't have a voucher if they had $4,000 a month in income.
Yes,
All right.
question right now.
Okay. Adding to the question that the person just spoke about, I kind of take exception to the math that you used there a little bit, because you said if a person has a voucher and your requirement is $4,000 a month, and the person's voucher covers $1,800, then you're saying that we should only require they have $400 a month in income. And the problem with that, of course, is how do they pay for groceries? How do they pay
That's
to
not your
use?
problem.
Yeah, it is.
Nope.
So, well, let me finish.
As a property
Well,
owner, that is honestly
well, let me
because
fin-
I'm sorry, just a second, just to interrupt, because maybe they have SNAP, maybe they have
need to show
someone
that.
else who is providing them with
to show those
supports.
things.
So
though.
in this instance, in regards to the rent, and I'm talking about the rent because CHA has already done all of that other background stuff to show, to show that they are only paying 30 to 40% of their income for rent. That's what I'm saying.
Okay, so for a market tenant, I require, in your case, that they show $4,000 worth of income. So if CHA is picking up 2,000, then the tenant needs to be at least show that they have another 2,000, that they have a job that shows that they're making $24,000 a year. If they have SNAP, they need to, bring that to the table. Just like with our market tenants, they have to show all sources of income to be approved for an apartment.
I mean, sir, this is your unit and your property. I am saying, and I'm providing you with the law and providing you with some examples. I honestly, you can do that because that's your property. I also would advise you that you should talk to an attorney because you might get complaints if that's what you're doing. I literally am just providing an example.
Okay, and then a second question is, on the other side of the coin, I've seen owners advertise, I only want CHA voucher tenants only. Is that also a violation on the other side of the fence?
On the flip side, I know what happens. Is that a best practice? I understand why. No, because they're not denying. And having a job is not a protected class, for example. Okay.
All right.
Y'all are coming in hot. Thanks.
Okay, my question is relating with this again. So, 2 questions. First, right now, CHA doesn't disclose how much is the CH portion, how much is the tenant portion in the
I'm sorry, say again.
Okay, right now, CHA doesn't disclose how much is the tenant portion, how much is the CHA portion, okay, until we got the final rental determination, right? So this is one question. When I talk about 2 times of the rent, okay, income level should be 2 times more. You are saying that this is a violation of the income. This is going to be the part of the income discrimination.
So what I'm saying is it could be. So this is like honestly just a high level example because obviously there are mechanics that go into, the affordability, the rental offer, all of that. So when you get into the nitty gritty, however, I think that what people are are doing on the front end is denying people with a voucher because that voucher holder can't show 3 times of income. And what the law says is that because that most of that housing payment is covered by the CHA, it's almost akin, even though it's even better than having a cosigner. So it's akin to a college student having a parent cosign, right? The difference is CHA is guaranteeing its portion of the rent.
Understand, that's what I'm saying. We don't know how much CHA cover the rent, right?
I know,
Therefore, how can
until you
CHA
go through, but in broad generalizations, so I'm sorry I can't give you a yes or no, because there's so much gray. But I do understand that, yes, they have to go through the process and figure out if that rent offer is accepted.
We got a question here.
I have a quick question in regards to disability and a protected class. Something that I'm seeing a lot in my properties, seniors with Alzheimer's and being at risk for um, water being left on for a long time or constantly losing their keys. And then another senior I have is on a second floor, but her arthritis is so bad she's can't really get down to the first floor. But she's not someone I really want to retain because she doesn't pay her rent. So they are a protected class with CHA. Is there something CHA has done to help those tenants out?
So that's a whole different issue. And I think that's more difficult. And I will let you know, I don't know everything here at CHA. I've been here 5 months. Okay. But that actually, so if you would, let's talk, because I do think, I'm not sure what the services are for someone who is actually aged in place and now can no longer take care of themselves. And so that's probably going to be a whole other set of alphabet soup of agencies to try and figure out what to do.
So I have a question circling back to the not the service animals per se, because the service animals are pretty much covered and it's documented. However, we found lately that the animals that are accepted or we have to accept as a emotional support animal. Okay, so you say that we can request documentation. So I don't know if you guys know, but you can go on the internet and pay $15 for a psychiatrist, and then it's going to issue you a paper, and I have to accept that. And then this guy
So-
showed up with that paper and 2 pit bulls, 55 pounds each, that these are his support animals.
Ooh, okay. So now we're talking about
Take
nuances.
the support animal. I'm asking if there is any kind of standard that CHA adheres to regarding the support animals.
No, because now here's where I do say this. All right. So, yes, I do know. And especially after COVID, there's a lot of telehealth. So I would never tell and give a blanket statement that you should not or accept, an online health provider, because yes, after COVID, it's changed a lot. What I would say, they would have to provide medical verification that whatever they need, they require 2 animals. I will give you my funny example of the person who came to me who said that their emotional support animal needed an emotional support animal. So when you were talking about that verification, I would hazard a guess that they are unable to provide accurate medical verification for 2 55-pound animals.
We denied this person, obviously, because this is, ridiculous. Now they left a Google review on our company, on me personally, that I am racist, not because I discriminated against the gentleman, because I discriminated against the race of the dog.
This is why I love housing.
Okay, we got a question back there.
Hi, I don't have a question. I wanted to address something this gentleman over here had said about the insurance, because I'm seeing a ton of this with all our different property managers and our building owners. So if you are accepting voucher or Section 8, the insurance carriers, the standard markets are declining you and they're sending you into the excess and surplus line market. So I just want to let everybody know that there's different programs out there, whether the National Equity Fund or there's other programs specifically for affordable housing. So you need to give them some time. A lot of them want 60 days or 30 days to review your account. So don't try to jump last minute and try to find someone to do your insurance for you, because you're going to get left up the creek without a paddle. So take some time, start about 90 days out. And there's a couple different programs out there specifically for affordable housing. Now, I agree 100%. We need to start letting Department of Insurance and whatever departments are the right ones to report this discrimination to, because it's happening widespread. One other thing I wanted to put on everybody's radar is what we're seeing right now is something called the crime score, which is like modern day redlining. So if you have a property located in a high crime area, then insurance companies aren't going to give you property or contents coverage for your buildings. So right now, more important than ever is to be ahead of the curve and start looking for some of these programs that are specifically designed for affordable housing. So, all right, thank you. I'm Jason Qualia.
And
I don't have the name of the programs. I'm sorry.
And just to tag team on that, and this is why I say that this is important. And I am a lawyer, and I know these cases, and they came out like in the late 90s. So what is old is new again, and so it sounds like people are going to have to file complaints about it. It's happening in the insurance. It's happening with your auto insurance, and yes, it is classic redlining. So thank you, Jason.
I got a question right here.
I would like to know.
I have a question.
I would like to know if.
Okay, go ahead, sir.
All right. I would like to know if this also applies to someone who has some type of mental issues like schizophrenia or some anger management or something along those lines. Would it be, say, would the landlords be held liable if they did not accept these persons because they had these mental issues?
Yes.
And also, if you have a tenant with these mental issues, would you also be held in contempt if you were trying to evict them because they were having the issues?
So there's a couple of, so one, yes, it would be discrimination based on disability if you did not rent to someone based on their mental health status. Now, that is not to say that if they become a tenant and then they are a bad tenant based on their mental health issues, because a person who is disabled still has to follow all of the same rules and regulations. So they're not going to be able to be disruptive. They are not going to be able to pose a danger to the health and safety of the people who work there or the other people who live there. So just because you have rented to them doesn't mean that there is no recourse if and or. So, I mean, like I said, again, I'm doing this in broad strokes. So these are all case by case.
Prior to renting as well.
I don't know what you mean.
Okay, so you get an application and then it appears to the landlord that maybe there are some mental issues that occur while you're trying to go through the process of getting the tenant, getting a potential tenant. And then to reject this person, if you reject this person, then they may raise that issue.
I mean, so if you were going through if you were screening, the thing I am just saying is that their protected class cannot be the rationale for the denial of renting. And I'll just leave it there.
I have a question for you.
And so I just want to time check. We're at 11:50. So let's about 8 minutes.
I have a question for you. I had a discussion with someone and they told me this. What I have a 5-room house, 2 bedrooms, living room, dining room, kitchen. My thing is, I only want 4 people maximum living in that house, and that is due to the 2 bedrooms. But I was told that that is discrimination, and the reason why they said it's discrimination is because, for instance, the living room could be converted into a bedroom. The dining room could be converted into a bedroom. So in other words, if I'm saying I only want 4 people in there because of the 2 bedrooms, now they're saying I can have 8 people can move in there. So my question is, by me limiting the population of that house to 2 people, am I discriminating?
Okay, so so there's also some exceptions regarding single family homes. So I'm assuming this is a single family home.
Yes.
And you are renting out the
Yes.
bedrooms. So this is where I would say you would need to probably talk to a lawyer to make sure that what you're not doing, but because you don't have any obligation to cut up the house to make it a
Even
living
though he's
situation.
not cutting up the house, he's not getting paid for the rest of it either. No, that's what she was just saying. She mentioned you can't cut the house.
Right, that's what I'm saying, that he doesn't have to. So, but I mean, I guess if you're gonna rent out those 4 bedrooms, you will get the rent for those 4 bedrooms. Or 2 bedrooms. Yes, I understand the 2 heartbeats per bedroom for a 2 bedroom. I got you. Is not discrimination to say, no, it's max 4 people. Based on the bedrooms. You don't have any obligation to do that. It's the 2 bedrooms, 2 heartbeats per bedroom, max 4 people.
I got a question.
I got you now. I understand.
For landlords that have an older building that maybe isn't up to standards for children under 6, which is a more specialized inspection through the CHA. You mentioned that putting not Section 8 ready is discrimination.
That's gonna be discrimination.
But how do we
So if you got a prospective renter with children under 6, and I'm assuming you're talking about like the lead paint hasn't been abated, something like that, that's not discrimination to say this is not ready, this is not, and I know already, this is not gonna pass CHA inspection, all right? That's not discrimination, that's being honest and not having somebody go through all of that to then waste further time trying to locate a unit.
Hi, how are you? My question is more general on the criminal background. So you stated that you can't look further than 3 years on criminal. Is that CHA?
No.
That's
the Just Housing Act. And I'd have to look it up again to see if it was the state, or I'm pretty sure it's Cook County. Yeah, I was like, it's
Cook
I got a lot of
County.
law in my head. But yeah, that one is one of the newer ones. So it's yes, county.
Oh, that's good to know. Thank you.
A question right here.
Hi, can you speak to why the disclosure of the tenant portion of the rent is so delayed in the process?
That's a property manager. So that's going to talk to the hospitality. That's a program thing.
Good morning, and thank you for holding this for us and everyone. My question is regarding violence and criminal activity. If we witness a Section 8 tenant causing and providing these things, what is our next course of actions? Do they automatically get terminated? Do we contact you for assistance? How do we go about that?
So again, that's going to be a program. Come back to the Ask CHA for the general. All right. Like I said, I've only been here 5 months, so I don't have all the ins and outs of all of the different program requirements. And so yeah, come back.
Okay. Thank you.
Thanks. All right.
Question right here.
So I work in permanent supportive housing, and so everyone
Thank
has
you.
to have a disability. I've had issues in terms of requesting reasonable accommodations for paperwork with CHA. Do I contact the fair housing at the CHA.org for
Yes, please.
those, such as like
And then I'll give you my direct email so you can let me know what it is. Okay? All right. One more. All right. Thanks, y'all.
I have two questions relating to the service animals. First, suppose you have a unit in a condo building. Suppose you have a unit in a condo building and the management office for this condo building is implementing certain rules. For example, can they say the medical provider must be licensed in Illinois for Illinois properties? So, for example, if someone goes online, they get one of these $15 certificates that they are entitled to get the service animal, and they're licensed in the state of California, for example.
Yes, they can say that they're requiring for that exact example that because if you have a example, I'm asthmatic. It is not going to be hard for me to go to my doctor and get the note, right? So, and to make that accommodation and provide that medical verification.
Okay, and the other question is pertaining to a pet fee. If someone has a service animal, can they be charged a pet fee or any fee in order to have that?
I mean, I'm not going to say that they can't be charged any fee. I'm a lawyer. I don't operate in that. But the pet fee, no, because that is what the accommodation is. So, for example, it's a no pet building. The accommodation is allowing the service animal. Furthermore, it is not a pet, so you're not going to be able to charge an additional fee for that animal.
Okay, and one question regarding the criminal background, and you can't discriminate on that basis. Are there any exceptions? For example, if someone has a murder conviction or is a registered sex offender.
That now we're gonna go into so yeah, but just in general. Okay. All right. Last one.
Good morning, Kimberly. Real simple question. If you have non-smoking facility units and a person says, I need to smoke marijuana.
So I'll just say under the federal stuff, there's no exception for marijuana. So I'm pretty sure that's one of the HUD regs. So again, I'd have to do the research to get the exact like reg and citation and everything. But I'm pretty sure that one you're not gonna be able to. So. Right. So that's why right. So that's exactly what happens in this instance, that the federal law is more. So she was just saying, I'm repeating the comment, the federal law is more restrictive than your state and local law. And in that instance, you've got to go with the federal law. It's going to be on top of all the other ones. All right. Okay. Thank y'all for your time. Appreciate it. Okay. So I'm sure you're going to find it. Lunch is in the other rooms. And at 1, come back. All right. Thank you. Jason, thank you so much. I was like, I'm just going to wrap that. Thank you. I appreciate that. Of course. Oh, sure. You mind taking a picture of this real quick?
think it's on. Is this on? You can hear me? Oh. We good to go? It's 1 o'clock? All right, everybody. Thanks for coming back after lunch. All good? There we go. All right. Hello, everybody. I'm Shannon Wolf. I am with CHA's new Healthy Homes program. I'm an environmental health and safety manager. I'm here with my colleague, Megan Bauman, who's also going to be presenting today. We're super grateful that you've come back from lunch, like I said, and are here to rock with us for an hour. We're going to talk about safe and healthy homes. A couple housekeeping things. If you have a CHA or personal account related question, please visit the hospitality desk. It's right outside this room. You can also connect with our owner outreach team via email at owneroutreach@thecha.org, and they'll be happy to help you. All right, let's get into this. So who are we? Like I said, we are CHA's new Healthy Homes team. We both joined the organization May of this year. That's about how old this program is. So we're just getting our feet under us, but we've been doing a lot and we're super excited to share with you the information that we have for you and what we might be able to help you with moving forward. We are comprised of 6 staff and 1 director. Our primary focus right now is management of lead-based paint hazards. We're kind of going all in on that issue area, but we're dabbling in some other things and hoping to build out programs for those as well, including mold, indoor air quality, pests and pesticides, sustainability. We're ambitious and we're ready to build out this program even further in 2026. I'm going to put this up a couple times throughout the presentation, but our team's email address is over here. It's healthy_homes@thecha.org. There's also our website there where you can find some more information about us. If you have questions and you're looking for technical assistance, guidance, you're trying to figure out what are the regulations, we're happy to try to help you troubleshoot that. That's the best way to reach us. I'll also mention we have copies of these slides printed out for you. I think most of you at least. But if you don't end up getting a copy, I'm not sure if we have enough for everybody. Again, you can email us at that email, and we'll be sure to get you the slides. Let's hop into lead-based paint. So back to the basics. What is lead? It's this naturally occurring bluish gray metal found in the Earth's crust. So it's around like many other toxins. They're naturally occurring. You cannot see it with the naked eye. It won't look like this. It's usually constituted in something else. It's in another form. Maybe it's in dust. Or maybe it's been used in something like a lead pipe or lead-based paint because conveniently and inconveniently, it doesn't biodegrade over time, which means it's useful for making materials more durable. And that's why it was used so prevalently in paint in the earlier part of the 20th century, especially on outdoor surfaces, because it would help with keeping the paint fortified against weatherization. The downside now is that we know that it's really toxic when you're exposed to it, especially for children. And unfortunately, the reality is that homes built before 1978, which is tons of the properties in an old city like Chicago, still have some level of lead-based paint in them, which when it chips and cracks and peels or just naturally degrades over time, creates lead dust. That is a hazard. Where is it found? So it can be found really anywhere. Like I said, pre-1978 homes typically have some layer of lead-based paint. It's probably not the most superficial layer, but somewhere in there, there's probably lead paint. A lot of what we're finding in the Chicago area, and I'm told nationally as well, is that especially these outdoor, like front porches, back porches, very common to see that as lead-based paint, again, because it was helpful against weatherization. So yeah, if you have a porch that looks like this, you might want to get that tested and make sure that's not lead-based paint. Why does any of this matter? So according to the EPA and the CDC, there is no safe level of lead exposure for children. Even at very small quantities, lead has been known to cause behavioral issues, learning disabilities, low IQ, hyperactivity, slowed growth, hearing problems, anemia, other core issues. This can be really debilitating over a person's lifetime. And the good news is that if you catch it while someone is young, you detect it in a lead test, there are things you can do to lower the level, but the main thing is primary prevention, not letting the exposure happen in the first place. And if it is happening, to figure out what is the source and to address that source. You hear a lot in the media, especially the last 10 years or so, about lead service lines, lead in water, and I'm not going to downplay that. That's absolutely a concern. But just statistically speaking, by and large, lead exposure is still predominantly happening because of lead dust coming from paint, from housing. So just putting that out there, don't forget to think about the paint. The water is a problem, but the paint is still the largest exposure source as of right now. And it's not just young people that are particularly susceptible to the negative effects. Lead for pregnant people, exposure can also lead to negative effects for the mother and the fetus. Lead can pass, it gets into your core organs and your blood, your bones, and it can pass from the parent to the child through the placenta. So this puts the parent at risk for miscarriage. The baby may have some defects, be born too early or too small. It can have lasting effects on the baby's cognitive growth. It's no good. We don't want it. We don't need it. It's preventable. Let's prevent it. So there's 3 rules that I'm going to outline today, 3 federal rules that apply to homeowners who rent out their properties for profit. So that applies to you all, it applies to us as well as CHA. These are 3 core things. And again, we have these printed out, copies of these slides. So don't feel like you have to jot all this down. But the first is the disclosure rule. So before signing a lease, the rule requires lessors of housing built before 1978 to do 3 things. First, if you have any knowledge of lead-based paint in and around your property, you're required to disclose that to the person signing the lease. You're also required to provide a copy of the Protect Your Family pamphlet. If you don't have this and don't know where to get it, please reach out to us at that email. I'll put it up again at the end. We can help you get that. Last, you're required to provide a lead safe warning statement informing of the health risks of lead exposure. I don't think that there's specific language that you're required to use in this lead warning statement, but I bet at this EPA website, I think they have some recommended language that you can use that would cover your bases there. That's just letting the lessee know that regardless of whether or not we know if there's any lead-based paint in this unit, just know that lead-based paint is a concern and it's something to be warned about and keep an eye out for. The second rule I'm going to outline is the RRP rule. This stands for renovation, repair, and painting. Can I just get a show of hands if you've heard of this before or have any familiarity with it? Some of you? Okay. This is a super important one. So the federal RRP rule requires any work that disturbs more than 6 square feet of a painted surface in a pre-78 residence to be conducted by a lead-safe certified contractor. So this is bathroom remodel, kitchen remodel, even plumbing work can count. Anything where you're disturbing a painted surface more than 6 square feet is required to be done in a lead-safe manner by a lead-safe certified contractor. At this address down here under Find a Certified Professional, I know it's kind of an unwieldy URL. You can blame the EPA for that. But they have a registry there where you can find out if the person that you're hiring to do this construction work, this renovation, if they are RRP certified. Basically, RRP regs come down to safe work practices, cleaning up after yourself, putting up containment. It's not dictating anything specific. Well, there's some specific, but it's mostly not dictating how the person does the work. There's some rules about, like not sandblasting a lead paint surface and things like that. But mostly it's containment rules. It's about how to lay down the proper plastic sheeting and clean up after yourself so that you don't fill this home with lead dust that might not have been there before, but now that you've cut a hole in the wall, now it's exposed, right? So this is a really important one and a huge preventative tool for keeping our homes lead safe. So what you need to know about this, again, if you are hiring someone to do any sort of renovation work on your property, and honestly, at CHA, we're not even abiding by this 6 square feet thing. We're setting an even lower standard. We're saying any renos that we do, we're going to do lead safe work practices, right? If it's 5 square feet, we don't care. We're going to do lead safe work practices. So hire folks that are certified. And if you're doing a DIY project for your own home that you rent out, you are required to be a lead safe certified worker. That's not for your home that you live in, but if we're talking about a property that you rent out, you're required to be a lead safe certified worker. The good news is all it takes to become lead safe certified is a 1-day course. And you can find out information about how to find an accredited course at this website down here. If you go to epa.gov/lead, there's a lot of information on there. Basically everything that you can want to know about how to be in compliance with the RRP rule, you'll find it there. And then just another note on RRP, I wanted to put up some pictures here of what it looks like when this is done wrong, right? So if we didn't have RRP in place or if work is not conducted in an RRP safe manner, this is what you might see on the other end. So these are some properties that we've seen lately that have had work that clearly wasn't RRP. How do I know that it wasn't compliant? Because there's dust everywhere. There's debris thrown out on the lawn. That's literally exactly what the rule is designed to prohibit, for the basic reason that if these happen to be lead-based paint surfaces or have any layer of lead-based paint in there, maybe it was 40 years ago, but you cut into it now and now it's exposed, and now this is lead dust, that can easily be tracked into your home. We know that kids are always on the floor. They've got sticky hands. They're always putting things in their mouths. It's a very easy and clear way that they can become exposed. And like I said, even a small level of exposure can have really noticeable and debilitating effects on a kid's life. So this is what the RRP rule is designed to prevent. If you are having work done on your property, even if you hire a lead safe worker, they've got the certification, but if you show up and it looks like this, maybe recheck their paperwork. Come talk to us if you've got questions or concerns. It should not look like this. That's what the RRP rule is there to prevent. The last rule that I'll go through quickly is about lead abatement. So RRP that I just talked to you about, which applies to all basic renovations, remodels, things like that, that's a federal rule. Abatement, on the other hand, is state regulated. So that's Illinois Department of Public Health. So lead abatement is different from RRP because RRP is just, you're going to do any sort of renovation, repair, remodeling, painting, and you happen to be taking steps to prevent lead exposure. Abatement is when you're like, I know this is lead and I'm going in specifically to take it out, right? I'm going to remove this wall. I'm going to strip this surface. That's what lead abatement is. That's got even more strict regulations and that's state regulated. So the definition of abatement is work that's being conducted with the express purpose of removing or remediating a lead hazard. And the regulation is that workers must be licensed with the state of Illinois to perform these activities. For workers to get lead abatement licensed in the state of Illinois, it's several days of training. It's more intense regulations and training. And that these workers in these suits, that's more of what you'll see for lead abatement work, right? Because they know it's a hazard and they're protecting themselves and the families that live there. What you need to know from this, if you're looking to inspect for, remove, or address lead hazards, that's all state licensed and state regulated. So make sure to hire state licensed abatement professionals. All other renovations, anything that's not specifically abatement, follow RRP. All right, that's kind of the decision tree that I would follow. just a quick recap. We talked about 3 rules. Disclosure is about telling folks what may or may not be in their home that they're about to sign a lease on, letting them know what you do know, and informing them of what basically you don't know, what could be, and we're not sure. RRP is just about hiring the right professionals to do any sort of work, remodeling, painting, anything that might disturb the painted surfaces of your house. And then abatement is for detecting or remediating, removing any known hazards that you have with respect to lead. We'll have time for questions at the end, but for now I'm going to pass it to my colleague Megan. She'll talk about mold management.
Hi, everyone. Good afternoon. Hello. Hi. My mom and dad worked in healthcare and like rehab. And as a kid, they would be like, oh, camping is dangerous or like riding your bike is dangerous because they had seen the worst of the worst. And now my mom says, well, Megan, you're like that with all building hazards because I'm like mold and lead-based paint. And so what goes around comes around. I know we're not giving you the most like upper talk this afternoon. A few things that we did bring, and I don't know if they've been handed out yet, but these we do have enough for everybody. They're Renovate Right pamphlets. This relates to what Shannon just shared. These we give to everybody who is going to have renovation work in their units. And these are the rights that tenants have and just so they know what sort of renovation work should be happening if they live in a building that's pre-1978. So that's also for you. Related to our next hazard, which is mold, we brought an EPA flyer on moisture and mold management. Again, if there aren't enough of these and you're interested, we're happy to send them to you. Shoot us an email. And then third, work safe practices, also related to RRP and what Shannon just went over. All right, so on to our next hazard. Who has seen mold in either their building or another building? I saw it in my basement a few weeks ago. Yeah. Any other, like, feel free to just yell out, like, where else have you seen mold in buildings? Bathrooms? Refrigerators, oof. Ugh. Windowsills, yes. What else? Oh, front-loading washing machines. Even top-loading washing machines get nasty in there. Yeah. Bathrooms. There's like a hole in the sink. I just moved into a house and there's like a hole I noticed in the sink where like water drains, but you can't, it's filled with black mold. And I don't know who designed that, but got to figure out how to clean it. Okay, so mold is part of our human health impacts within a living space. And this is what our Healthy Homes team thinks about here. So it's like one component, like lead-based paint, like water damage, like pests, that contribute to keeping a home safe and healthy for whoever's living there. Why do we care about mold? Molds can kind of trigger allergies that people have. This is a really important point. Whether mold is dead or alive, even dead mold can like trigger allergens that people have. So if you have people living with asthma, I see some people nodding. If there's people with asthma or respiratory illnesses in the home, even like dead mold needs to be treated and kind of dealt with because that also releases spores and things that can like trigger off those respiratory symptoms. It can release irritants, depending again on the person and their health and their bodies, that can be mild or severe. And some forms of mold, there are many, many, many forms of mold, can be really toxic. So that's on the human health side. Also for us as building owners, we are concerned about like our financial assets in that building. And if there's mold, there's water damage, and that's gonna be a structural issue for us. So this is both a human health aspect for residents and those of us living in homes, but this is a financial and structural concern for us as well. So this is why we're nervous about mold whenever we see it. So back to basics. Mold is not going to be present unless there's a water problem. So this is really, we're here to talk about moisture issues in our buildings. It's not just in Chicago. Chicago's built on top of a wetland. So here we can't escape it, but this is everywhere and it's both inside and outside. So when we test Usually we don't do mold tests, and we don't recommend that you hire a laboratory to do mold tests either, because we'll get to that. But when they test for mold, I think it's instructive to know that the comparison for inside of a home is whether it's comparable to the mold in the air outside of the home. So mold is both inside and outside. It's something we're breathing all the time. So a few things, just again, y'all have been in this, so you know, but kind of ways to assess mold is to figure out first where the water leak is and then attack the moisture problem. So we need to find out where water's coming into a space. So where's our waterfall coming in, and then how do we turn that space into a desert? As soon as possible, you want to dry something out. I always think of if you spill something on a carpet, you put a fan on it to dry as quickly as possible, for example. But this is the same in any other space in a home. And then controlling humidity. This is something that our team, as we're working primarily in public housing. We're not yet working in HCV areas, our team. And a lot of public housing units don't have air conditioners. And so kind of controlling humidity is a real problem. But for those of you maybe who have maybe more control over your spaces, that's something that you can consider as well. So I said that we usually don't recommend that people hire a mold assessor to do laboratory testing. Why that is because mold you can see and smell often. If there's a mold problem, you're gonna get one of your friends who has a great sense of smell to walk into a room and tell you, unless it's really bad. You're gonna see it. You're gonna see the markings on the wall, like here at the baseboard of a basement. You're gonna see a water stamp or mold, the splotches that we all recognize. And you're gonna feel if that room is damp. So really it's a sensory experience. You all already set us up for this, but just some areas in your building that might be considered for mold. Windowsills was not a thing that I thought about too much until I had unfinished wooden windowsills, and those were bad news from the get-go. I think in the winter, it gets really dry in Chicago, so people have humidifiers, but then those humidifiers can produce excess moisture. So all these little things that maybe the goal here is just to provide different forms so that we can kind of, as building owners, think what should I be aware of where moisture might be coming from if I see, smell, sense, or feel some dampness or see mold in a space in my building. Here, again, prevention tips. Think about relative humidity, ways to control that if possible. Ways you can do that is vent moisture generating appliances to the outside. Run fans or open windows as are appropriate. So some units don't have vent fans over their stoves, like hoods. So if there's ways to open windows or make sure that there's easily accessible ventilation in kitchens, for example. This was a picture of a dehumidifier in a basement. And then the do's and don'ts. The one thing I do want to point out here is that most of us think oh, mold, I'm going to clean it with diluted bleach water. And we're here to tell you that's not great for health. Bleach isn't what we would best practice recommend. If you see visible mold that's in a really large space, you can hire somebody to clean it professionally. Otherwise, the mold in my basement right now, I'm scrubbing with dish soap and water. That's a safer way to do it than using bleach. Yeah, so that's one of the things that we're trying to spread. So again, you can think about just really practical things. And if you have people living in your spaces, you have tenants, this might be an opportunity for you to give them a bit of education if they're not sure, they haven't learned how to control the moisture in your unit. So making sure that windows are closed, telling you if there's visible mold somewhere. Bathrooms are a favorite. Making sure those bathroom fans or hopper windows or there's some sort of ventilation in the bathroom, and that you stress to your tenants, like, please use these things so I don't have to keep coming in and recaulking the tub and scrubbing off the ceilings, right? Okay. So we just gave you a lot on these, our two favorite hazards right now, mold and lead. We also, our team has a lot of expertise in asbestos, if this is something that you're concerned about in your building. We're working a lot on indoor air quality generally. So thinking about like the types of paints used, the types of stains used, the types of cleaning products used, and how that affects the health of the people in that space. Radon testing, especially for basements or ground floor units. And then pests and pesticides, which is my least favorite. But if you have questions, we started it and we want to end it this way. Please email us at healthy_homes@thecha.org. I said we've been working mostly in like public housing units, but our team is here for homeowners also. So please like shoot us an email, ask us questions, we'll get back to you. And with that, we have some time to take questions now. So yes, in this section. Okay, we'll do section 2 in the back, and then we'll do this gentleman in the front.
For buildings that are getting gut renovated, that literally they follow, the construction guidelines and all plaster, all drywall, like even studs getting removed. Even though they're pre-1978, do you have recommendations on ways to avoid the below de minimis inspection situation where it's maybe a corner of a wall that always gets brushed and it gets chipped or scratched, and then every year, every 2 years, you got to retouch it up and corners especially are really hard to repair. So any suggestions on how to best take care of that during construction so that that becomes less of an issue?
So you're saying you've stripped down to the studs, and so you're confident that in reality there's no lead-based paint left in the home, but you still got these regs hanging over you because of the age of the building. Is that what? So that's a good question. We can look into that a little bit more, but my gut is saying that the key to that would be paperwork, documentation, like really solid documentation demonstrating that you have stripped down to the studs. And if you can show, thoroughly and accurately that you have removed the painted surfaces in the home, then I think that would suffice if you came up against like a regulatory issue. But that's a good question and one for us to look up.
So would like construction drawings and a approved City of Chicago building department permit suffice?
Yeah, I would keep all of that. Anything that shows that I can point to and say, was this wall removed? Was that wall removed? Was this staircase anything that shows that level of detail and granularity, I would hang on to. And I think that would be your best bet in
Great.
combating those
And then,
regs.
sorry, don't want to commandeer this, but just now if I, do CHA tenants for the next 10 years, do every year I have to show, yes, this wall was gone. Okay, is there a way to like keep that on file so that during inspections, the inspector knows like, yeah, this drywall's 2 years old or 8 years old or whatever?
Great question. We're actually working on figuring this out for ourselves right now too. We're jotting down your question. Maybe I can give you my card after, or that email we also monitor. But thank you for the question.
Another one right here.
Yeah, my question is almost same with this person. Okay, from time to time, CHA inspector require us to do the lead-based paint test, right? Even we completely demolished the house, they rebuild the house. Then from maybe 5 years ago, we did the demolition and rebuild the house. Then 5 years later, paint is a bit it's peeled. Then we got the request of the lead-based paint test. I explained many times, this is a completely new steps, but still we got the required. Therefore, from time to time, not every year. How can we avoid this kind of things? We know there's no lead-based paint.
Yeah, if you've had an inspection done before that said these walls have no lead, and I should say when they inspect for lead, and they'll use something called an XRF. It looks like a taser or stun gun almost, yeah. But it shoots through the wall, and it doesn't just test the surface layer; it tests through the wall, so it'll tell you if any of those layers are lead. So if you have an inspection report that says this is not lead, then it's not like lead will appear later on. If it's not there, it's not there, and it's not going to be there because we don't use lead-based paint anymore. So that should cover you. But if you're saying this is an issue of like CHA's programs not talking to each other essentially and not keeping track of the past inspections and the reports, that is very much something that we're working on building out. Is, we know we have like these Inspire inspections and these different inspection programs and requirements, and we're working as a team to try to integrate our findings and our documentation with others so that you don't come up against that issue moving forward.
I feel that there's no consistency. Okay, we have lots of similar houses, similar steps, but some are required, some are not. Therefore, I just wonder what kind of factor, what kind of factor they're looking at, to let us do that kind of test. Test costs $500, $700.
Yeah, they're not cheap. I know. Yeah, and it's a good question. I honestly don't know the answer to that. We'll jot that down and we'll look into that. Yeah, go ahead.
In regards to healthy homes, this is not lead-based paint, but if you have someone doing masonry work and there's dust, is there a concern about any kind of bad residue for the tenants? I do have a tenant that's been complaining.
I think that could be a concern. I know that first of all, it might be a concern outside of lead. But even with regard to lead, I mean, you could have some sort of situation where like there's like a glaze on the bricks or something that potentially could have lead. But I would say also the thing that I like about RRP and why we're not only following it for the properties we're required to, but we're saying we're going to use RRP for everything, is that it's also just generally best practice for the home and the people that live in it and the neighbors, right? Like, I don't care if it's lead or not. I mean, I extra care if it's lead, but even if it's not lead, I don't want my home filled with dust with whatever from the sheetrock or whatever, or the masonry. So I don't know if from a regulatory standpoint, I think if it's not a painted surface, I don't think RRP is going to apply there, but I would still look for a contractor that's going to do proper containment. If they do it right, you should never see like dirt and dust coming from their work into your yard or into your home, because that could have other toxins in it as well. A question over here in the front.
Thank you. Regarding the RRP rule, you mentioned something about 6 square feet of painting and disturbance.
Yeah.
How do you define disturb?
Great question. So I don't want to misspeak because the best thing to do would be to quote the regulations exactly by how they define it. The best thing I can tell you is that if I connect with you or if you shoot us an email, I can send you the exact passage of what all it includes, because I don't want to misspeak right now. But is there something specific that you're thinking of? Would it count or would it not? Or just
generally
basically
speaking.
what the rule is designed for is that, let's say that you have a wall that has a layer of lead-based paint, but then it's covered with 3 layers of newer paint and it's perfectly intact. Even though that is lead, even if the lead was the outermost layer, it's actually not a hazard. It's a hazard once it begins to chip or crack or peel. And so if you have a surface and then all of a sudden you're sawing into it, you're cutting a hole, you're demoing something, you're doing anything that's opening up that surface. It's like if you were to cut your skin, right? Like it's the same thing. If you were to open that surface, all of a sudden, then lead dust can be created. And so it's designed to regulate that specifically. I don't know if that's informative or not, but.
Okay, one other question.
Sure.
You said don't use bleach. Like, for example, if you see mold in the shower area, soap and water was one suggestion. They do sell commercial products that you can buy, which are specifically for the purpose of addressing mold. Would you consider that to be a no-no, or is that on the same line as bleach, or it's not a bleach product, but?
Right. Do you have anything?
I can.
Sure.
Yeah. So mold is really different from lead because it's not a regulated hazard. So we can say like, this is what best practice is, but there's no like firm black and white line to point to, which is to say, depending on the product and depending on, I would say like the people in the space, you just want to be really careful with like ventilation or using really intense chemicals, especially around people with respiratory issues, pregnant people, young children. So if using, I think best practice is like, look at what ingredients are there, do a little research on like the health hazards that might be associated with them. And then when using any product on mold, just make sure there's really good ventilation,
Right.
so that those chemicals or whatever is being used aren't trapped in a space.
So wear a mask and leave the bathroom door open.
Yeah, for mold, it's like wear a mask, wear gloves. If you have goggles, wear those.
Mhm.
Yeah. Maybe
One thing about so what the EPA says about cleaning up mold is that the one exception to not needing to use bleach is if you know that there was an exposure to sewage water. So if there's been like a flood and like the sewer system has overflowed, like then you would use bleach. But that's the only exception. The reason they say don't use bleach is not because the bleach is not going to be sufficient for the mold. It's because it's overkill and it's not great for our exposure. So if you clean something with bleach, make sure, like Megan said, you ventilate. If you can still smell it, you're being exposed to it in a way that's not great for your lungs and your body.
Thank you. Thank you for sharing this information. I'm currently dealing with a scenario. Currently, we are in the process of acquiring our pilot project, which it does have mold in it. We are also a nonprofit HUD approved housing provider. And I wanted to know, are there any federal grants or any funding to help to address and also to eliminate, these type of issues and, supplies for homeowners or investors that might not have the ability to have a mold test done or, just cleaning out, the mold?
About mold, I haven't seen any. This is a good question. We've been looking for this for lead. We haven't come across mold funding yet, but I don't want to say it's not out there. Shannon said maybe check with the city of Chicago if there's any options there. I've been looking through Cook County for those of you kind of like farther outside, and I haven't seen any there as well, but I wrote that down. We're going to look into that too.
Thank you.
Yep. Sorry to not have options.
It might be worth considering, like there might be some sort of supplemental funds that you might be able to get creative with, like if there's a grant for lead safe housing that you might be applicable for, but maybe they have some supplemental funds that it could be like and other healthy housing principles or something. I would try to, especially with mold, since it's not regulated, it's kind of the Wild West out there. But try to get creative maybe with what you might be able to, like, two birds in one stone type thing. Right here in the section.
You're gonna look into, are they gonna be on the newsletter that comes out? How we gonna know?
Yeah, that's a great question. We can talk to, I think just started getting a little segment in the HCV newsletter. That's a really good suggestion. Maybe we'll be able to pop some of the questions or the answers to these in there. I also would like us to stand up a like FAQ page at some point on our website for some of these. Frequently asked questions, FAQ. Oh yeah. For a copy of the slides, you mean, or the ones we talked about?
You had put a, what you call them on the board there a little while ago.
Oh, like the the one you're required to hand at disclosure. So we don't have that one on hand today. But and I'm not actually sure if we have any of those currently in stock. I don't know that we do. Yeah, that's on our to-do list, just to get more of those ourselves. But if you need some, we can try to hook you up with those. Anybody else? Sure.
Hello. But we were wondering if there's any funding or grants that are offered for specifically residential multi-unit properties, non-commercial or mixed use, either through CHA or no, I noticed that in TIF or SPIF, that's not so much of an option.
For lead or for something else?
For more reconstructing of projects.
That I'm not sure about. Let us look into that. Is there one over here? Yeah, right in the front here.
I wonder if you could speak a little bit about why you don't recommend doing mold testing, or like what alternatives you would suggest to like addressing such
Yeah,
matters?
great question. So having like a mold inspector come with all their tools and then sending samples, like if they're gonna swipe a surface, sending samples to a laboratory, it's really expensive. Like it can be multiple thousands of dollars. And because mold isn't regulated, it's hard to find like a standard. Like the results would be like the mold in this room is above X, like the outside is 5 and the mold in this room is 10, and it doesn't give you much information on like what to do with that. Whereas if there's a real mold problem in a room, you're gonna smell it, you're gonna see it, and you're probably gonna feel some dampness. You might see some like water damage somewhere. So with that, with your senses alone, you should be able to figure out the most important thing. Remember, where's the water coming from? Where's the moisture coming from? So if you sense that there's mold in a unit or in a space in a unit, your first question should be like, where's water? And how can I find that? And then how can I fix it? So like a few examples in some units we've seen recently. Which ones to think about? There was like some mold in a ceiling. And we were like, oh, there's a roof problem. So we like fixed the roof, scraped out the ceiling, repainted it. There was a really bad bathroom, like really rough, and there were kids living there. And so we did like an immediate cleaning, recaulking of the tub. Then we made sure the hopper window was being used. But truly the moisture issue was that the upstairs unit had water running down the wall into the second floor unit. So we like fixed the plumbing upstairs. So like always for mold, it's about a water issue. So figure out your water issue, fix that first, and then deal with the mold on like the painted surface or the wall. And worst case, you need to like replace the wall, right? But a lot of time, if you can catch it early, if you're inspecting, if you're looking at your property regularly, you should be able to see like the start or smell the start of a mold problem and then fix the water issue right away.
All right. Thanks. Thanks, everybody.
We have housekeeping. Okay, this concludes our presentation. Bum, 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 bum. Thank you for your time today. Lunch happened. We're here. Okay, that was actually it. Okay, thanks.
Okay, so we would like to thank everyone, and then also, please, we still have our networking break, an afternoon snack in room 318, 319, and then we'll see you in the next session at 2:30 here. Thank you.
Everybody, please exit through the front doors. Please exit quietly through the front doors. Thank you.
Hello? Oh, it's working. Okay. Hello, everyone. Hi, hi, hi. You good? Oh, okay. Good afternoon, everyone. Can everyone hear me? Great. My name is Danielle Thomas, and I am the director of CHA Owner Service. Welcome to the HCV Program Town Hall, the last session of the 16th Annual Owner Symposium, excuse me. When you register for this event, you may recall having the option to submit a question for the HCV Program Town Hall session. We're going to be answering those questions you submitted during the town hall today. So thank you to everyone who submitted a question. Please keep in mind, we're going to be answering the most common questions as we receive hundreds of submissions. We anticipate this session is going to take the entire hour and a half. So if you have any questions outside of this, please reach out to our owner outreach team at owneroutreach@thecha.org. Oh, the screen. They don't have a screen? One moment, please.
Otherwise, it's going to be too bright for the.
How are they going to see
The PowerPoint is going to be on both sides, either side.
Okay.
On both.
All right. So,
Otherwise, it's going to be projected on their face, though.
oh, so this will project on their face. Okay. So because if we put the screen here, it will project on you all's face. We ask that you look at the screens to my left and right. Thank you. Okay. So without further ado, please join me in welcoming our panelists for this final session. First, we have Assistant Director for the HCV program. Please welcome John Acuff. Yes. Next, I'm pleased to introduce HCV Senior Program Manager, Vincent Bruton. Thirdly, please welcome HCV Inspections Assistant Manager, Earl Miller. And finally, joining us is the Director of HCV Tenant Services. Please welcome Sherry Williamson. Good afternoon, panelists. It's great to see you this afternoon, and welcome to the symposium. Okay, you guys doing okay? You ready? All right, let's get started. All right, so question one for the panelists. What is the timeline for leasing up with the HCV program? Is it supposed to be?
Hello, good afternoon. Can you hear me? All right. So we know that when a tenant submits a request for tenancy approval, you all would like to receive payment as soon as possible. The Housing Authority does make a concerted effort to make sure that that process does go as quickly as possible. But we have a lot of regulatory requirements that we have to do in order to get the payment going. Those requirements, if everything goes smoothly, does take about 7 weeks. So why don't we just basically talk a little bit about what that process is to becoming a Section 8 landlord. So the first step is to participate in an owner briefing. At the briefing, they will educate you on all of the requirements to be an HCV owner. The next step would be to market your property. There's a website we work with called affordablehousing.com. I know there's a bunch of other websites out there where you can put your property out there so that prospective Section 8 tenants can be aware of it and possibly live in that unit. The next step is to select a tenant. As a former landlord myself, we all know that it's easier to move somebody in than it is to move them out. So the Housing Authority conducts eligibility for a voucher, but your job is to do your normal screening for suitability as a tenant. You should do the same process that you do for screening for non-Section 8 tenants. So after you found a tenant, you will submit the request for tenancy approval. That's probably one of the most important documents. What typically slows down the process is omissions or discrepancies. So before you submit that document to our portal, just do a quick little check to make sure that every single box has been populated, every little question has been answered, there's no omissions or discrepancies, because that can delay the process. Based on that document, we will conduct what's called owner eligibility. So we have a process to make sure that our landlords are ones that are of good faith, that we can conduct business with. Typically, the owner eligibility means making sure that no landlord is excluded by HUD or excluded by the CHA. If it's an LLC, that they have a certificate of good standing or a criminal background check has been done, making sure that they're the rightful owner of the property, and making sure that they are current on their taxes. So if all that happens, we will make a rent offer. So you will put a requested rent amount on the RTA. We will run comps. We will look at other units in the market and make sure that those are equal to or around the requested rent. If we can find comparable units that can meet that amount, we'll offer the rent to you. If we cannot, we may give a revised offer. You have to accept that offer. And then once you agree to that offer, we will conduct our inspection to make sure that the unit is decent, safe, and sanitary. This gentleman will provide you all the details about that. After that, we'll get into the contracting piece. We'll send you a contract. You will sign it. We will sign it. And we do try to make sure we do 2 check runs, and we do try to make sure that if a contract is received, we try to pay it before the next check run, unless, of course, we receive it right before the lock date. So that's basically the process in a nutshell. I don't know if anybody wants to add to that, or if we want to move on to our next question. Yes. We actually have a question on rent increase, so why don't we wait to that question, and I'll be doing another presentation on that. It's similar, and then you can, if that doesn't address your question, we can discuss that further. Yeah. So my understanding is affordablehousing.com is a website where landlords can market their unit to Section 8 tenants. Yes. We use it for other business purposes, but that's one of the features of that. Affordable, it used to be Go Section 8. It's affordablehousing.com. Yes. Yeah.
Yes, all one word. All right, let's move on to question 2. The moving papers were submitted to CHA. How soon can the tenant move in? Who's taking that one? Oh, Sherry.
Good afternoon, everyone. So for that question, the tenant cannot move in until the owner eligibility has been completed, the inspection has been completed, and it passes, and then the tenant and the owner must create a date as when the tenant will move in. Once you guys have done that, then you can submit that information with the lease to CHA, and the tenant is able to move in once you guys have set a specific date. Please keep in mind that when a tenant is taking possession of the unit, they must have the keys. We get a lot of tenants who has not been given the keys, but have signed a lease. If you do not give them the unit, then the date of the lease may need to change. Yes, ma'am.
Is there a new regulation where it should take place on the first of the month or something just means the first of the month?
Yes.
The lease cannot start on the
The
first day
first.
of the month.
Right. The lease doesn't start on the first of the month. It can start the second.
Mhm. What do you say?
It's been quite.
I always put the date next day of the inspection pass. They always see it approved.
Okay.
So if there are new admissions or if they're porting in to our agency, they can move in on the first day of the month. But if they are a current participant, they cannot start a new lease on the first day of the month. To continue with, because if you start a lease on the first day of the month, it is likely that they're still living in the
the old
current
unit.
unit. So to not hurt the previous landlord, we start the lease on the second, any day after the first, because the previous landlord will still receive half. So for example, go ahead. Yes. So if a participant, a current participant resides in your unit, after the first date of the month, the owner can keep the half if they're still active on our program, because there are caveats to that. If they're terminated or something, but if they are current on our program and they live there after the first, you get the full half. They will get paid from the second to the last day of the month, the new owner.
Please keep in mind, one of the most important thing is communication. We get a lot of times where the owner, new and old, are not communicating when the tenant moved out or moved in. And sometimes it becomes a barrier for CHA to determine that information.
Isn't that on the tenants? We're supposed to coordinate with the tenant, but you guys cannot hold our hands well enough because the tenant can lie to us, they can tell us anything, and we can't talk to the new tenant because they don't want to talk to us. We're really relying on you to make that transition smooth, and sometimes you guys do not help us enough.
Okay. So we could do a better job with that if you can submit your questions or suggestions to that email
Owner
address that Danielle provided. We'll definitely take a look at that. We had another question. Yes, ma'am. You in the black shirt.
This whole, I'm sorry. And this whole, the landlord gets the HAP for the next month, that landlord will get that 30 days of rent. And then the new landlord will get 29 days of rent or whatever.
Yes.
Okay.
Emilio?
Anyone?
You said that it takes 7 weeks, right? Well, our experience is maybe 7 weeks, 8 weeks, maybe 2 months. Until usually it takes maybe 4 or 2 months almost. Therefore, we are losing 2 months out of 12 months. Okay.
So the housing authority does our best.
I mean, that's my question, my
what-
request. Okay. This has to be accelerated much more than this. We are losing 2 months rent. Can you be a landlord to losing 2 months rent?
I don't know the reasons why those particular cases took 2 months. Like I mentioned before, sometimes delays occur due to omissions or discrepancies. Unfortunately, there's just a lot of HUD requirements that we have to do in order to approve the
Have you ever
payment.
thought about how you're going to accelerate this process? Even you got to take out, okay, we upload the documents. Takes 1 week to confirm you got the documents, right? And then go to the inspection department. Takes another 1 week to set the inspection date. The inspection date is always set 1 week to 10 days after that. The first inspection is always fail. Takes another 1 week to 10 days. We are losing 2 months, okay? You got to do something, okay?
Can you just take one more question?
Question right here.
Hi, I just had a question. If we're operating off of a wait list, what is the typical time for the turnaround for the wait list when we submit the paperwork and waiting for the inspection? Because I've been waiting for over 2 months for that.
Emilio, can you give it a mic back for a second? When you say you're operating from a wait list, can you give me a little bit more detail?
A PVV wait list.
You an owner or a tenant?
I am a manager.
You're a manager?
Yeah.
So you've put in a request for us to inspect a unit?
So I put in the paperwork and then they usually notify me when the inspection is, but I haven't received any notification.
Okay, you
And
see,
and I followed up and still haven't received it.
don't leave. See me as soon as this is over.
Okay.
Do you guys have any recommendations for, let's say, tenant says, "Hey, I'm leaving in 30 days, 60 days, whatever it is," and you want to continue to renting through the CHA HCV program. You find a tenant. What's the most optimal way to narrow that window between move out of the last tenant and move in of the new tenant? Other than, I mean, let's just say that you got all your paperwork done, and it takes you a week to do a turnover of the unit, right? Repaint, fix, fix what needs to be fixed. What's kind of the most optimal process to follow to make sure that you get the new tenant in as soon as possible?
So I would say that would be that full process of approximately 7 weeks, because with the owners, we know that you guys may have to do some repairing, some things on your end. And so once you submit that RTA for that particular new tenant, then what it does, again, it takes approximately 7 weeks. So when we get ready to do the inspection, and I'm gonna pass this to Earl, the tenant has to be out.
The unit, yes.
Am I correct?
Yes.
Yes. So the thing with starting it while you still have a tenant is, what if that tenant doesn't move out?
Correct.
So then by the time we get ready to schedule you for the inspection, you're gonna have to cancel it. So that is just, that gray area where if the tenant is not moved out, because we all know sometimes it's hard to find another unit. So they're optimistic about finding a unit within 30 to 60 days, but we've seen some families take 180 days and even longer to find a new unit. So with that being said, you're starting the paperwork for a new tenant, but that tenant hasn't moved out.
Okay, so to be respectful of your time, we're gonna stop the questions here. We'll open it up at the end if we still have time, but we're gonna get to our preset questions. Thank you. All right, so question 3, how should I deal with a tenant who does not follow the lease?
CHA is not a party to the lease between the property owner and the HCV program participant. Therefore, CHA does not mediate any conflicts or disputes between the tenant and landlord. With that being said, in situations where the conflict is based upon a violation either of the HCV family obligations or the HAP contract, CHA will indeed investigate any reported or identified allegations. As that occurs, you should submit those reports to our enforcement department at adminenforce@thech.org. We would like to have these in writing. In addition, you should also include supporting documentation with this report. Examples may include police reports, notices of non-payment of rent, court documentation, and the like. With that being said, I need to underline and emphasize the fact that when it comes to lease enforcement, you should in your head not think that there's any distinction between a market rate tenant and an HCV program participant. They should be treated the same. CHA does not mediate lease enforcement. We don't approve lease enforcement. We don't approve eviction proceedings and so forth. Those are ultimately the responsibility of the property owner. you as property owner, landlord, or manager, as you exercise these options, be sure that you're doing so in compliance with the Chicago Tenant Landlord Ordinance, local and state law, and the HAP contract.
Okay, thank you. Question 4. What happens if a tenant violates HCV program rules?
So when a tenant gets their voucher for the very first time, they participate in a briefing and they go over the voucher with the tenant signs, which contains family obligations. There's a laundry list of items in which the tenant must do, and there's a list of items in which they must not do, and explain to them the consequences of violating any of those rules so that they are clear on what they must do in order to maintain the voucher. So when the CHA receives an allegation or a concern or some sort of becomes aware of a program violation, the CHA will conduct an investigation. CHA will consider the seriousness. CHA will consider the evidence that we have to support it. And the CHA will make a decision based on the facts of the case, the seriousness of the case, and the evidence that we have to support the program violation. Based on that, it could be something where we don't believe that the violation rises to a very serious level. It may be something like a warning. It may be something where they sign an agreement that they understand that this violates the rules, and if they do this again, there could be further consequences. Or if it's a offense that we feel is a serious violation, we will initiate termination of their voucher. Before their voucher can be terminated, the family does have due process. That's what's called an informal hearing. They have a right to legal counsel. All of our decisions are made in accordance with fair housing and civil rights laws. If it does go to a hearing officer will ultimately decide whether or not that tenant retains the voucher, whether they're reinstated, or whether they're terminated. So there is a process to do that. HUD and the federal government does give tenants due process before that voucher is taken away. So sometimes when there is a allegation of possible program abuse, if the CHA doesn't have a lot of evidence to take action against that, it may not mean that the tenant will lose their voucher, because when they go before the informal hearing, they don't have evidence to support that they violated the program rules. Yes.
Let's say it has 3 on it. 3 bedrooms, 3 tenants. What is the? I don't quite understand what you said. Like, what do you get as an owner to know what the violations would be, or what the HCV program identifies with the tenant? Do we get to see that? Or
No, we cannot disclose. Now, in the event, if we do initiate termination against a family, the first step in the process is you'll receive a letter. It's a very generic letter that just says, this is a heads up. We have initiated termination against your tenant. Doesn't necessarily mean that their voucher is terminated. It's just we've started a process. And then if it goes through, we'll give you a final termination, which will include the last date of the payment, as well as a clause that says if the family remains subsequent to that date, the family is responsible for 100% of the rent. As far as your question about the voucher size refers to what we call subsidy standards. The subsidy standards are used to determine what's called the payment standard, and the payment standard is the maximum amount that the housing authority will pay in the HCV program. So if a family finds a unit where the rent and utilities exceed that amount, the family will be responsible for incurring the difference for that, along with 30% of their income towards rent and utilities. So that voucher size determines, and it's very complicated depending on where they live, but that's what that is. It doesn't necessarily mean that they have to live in that size unit. It just means that's the maximum subsidy for that bedroom size.
But I think you were asking also, to piggyback off John, about how would you know what the violations are? Is that what you were asking? So if you look at the HAP contract, which is the contract between the Chicago Housing Authority and you, it will have the tenant violations on there, or the obligations, excuse me, on the HAP contract. So you haven't received it. You don't have a participant yet, a tenant yet. Okay, I will meet with you after, and then we'll further discuss. Is that okay? Thank you. All right, let's move forward so we can stay on time. All right, question 5. Does CHA move forward with a participant when they are not in good standing? What are some of the reasons that would cause a participant to lose their voucher?
So yes, to answer that question, it is yes. CHA does move forward with terminating families who are not in compliance with their HCV family obligations. Some of the violations could be unreported income. Some of the violations can also include lease violations. It could also include anything that it's on the family obligation that the families are not in compliance with. So you guys know at every recertification, we go over the family obligations with the participants. It's a 4-page document that they sign and date every time they do their recertification and new admission.
All right, thank you, Sherry. Question 6. Once an RTA packet is submitted for a new move and owner eligibility is confirmed, what factors does CHA consider when determining the rent offer?
CHA takes 3 factors into consideration when determining the rent amount for a new move, namely the asking rent, the market rent, and the HCV participant family's affordability. The asking rent is simply the owner requested rent that is listed within the request for tenancy approval. Affordability, on the other hand, is calculated by using both the family's income and then the subsidy that they are eligible for at CHA. This is also known at different places as the affordability rule or the 40% rule. In any case, the rent amount that we approve cannot be such that it'll require the tenant to pay 40% of their gross monthly income. So that's a particular cap. And then the other item mentioned, the market rent. The market rent is determined by analyzing the locality of the subject unit. Roughly speaking, we'll generally only analyze units that are located within a 1-mile radius of your subject unit. And we're only looking at units that are comparable, both in terms of bedroom size, bathroom size, included utilities, and amenities. So with those 3 factors in place, we're going to take a look at all 3, and the lowest of all 3 is what we're going to use to base off to determine what the rent offer is. Therefore, if you're asking for a contract rent of $15,000, but the market only supports $1,000, we're not going to be able to offer that that $1,500 amount. Excuse the amounts. Alternatively, it could also be capped by affordability. So if 10% of their gross income, 40% of their gross monthly income is such that we can only approve a contract rent amount of $3,000. Well, even if the market supports more and the owner's requesting more than that, we can't go above that amount because we cannot allow the participant to pay above that affordability cap. An important thing to note, which we'll talk about later, is when we're talking about new move-ins, the process of determining the rent that we can offer differs from rent increases. So keep that to the side for now, and we'll discuss rent increases in greater detail later. We don't, so if the tenant's already in the unit, we will do a rent redetermination if you request a rent increase. There's a possibility that we could also do one for quality control reasons. Maybe we found out that, hey, we approved a rent amount, but a mistake was made by staff. Maybe they didn't look at the market rent closely, and the market rent didn't support what you were given. There are different caveats to how that would be processed. It's changed over the years. So sometimes they would freeze the amount and not decrease it until a certain period of time has elapsed. Sometimes they would try to determine if at least one unit within the locality supports your current rent, and they may go with that instead of looking at multiple units. It really varies on a case-by-case basis, and it's changed throughout the years substantially. Yeah,
So when you say back rent, are you saying that? Mhm.
So there's two questions. One could be, are we redetermining the contract rent and saying, hey, we used to have an approved contract rent of $3,000. We're decreasing that to $2,500. Or is the participant undergoing an annual recertification, an interim recertification? Has their circumstance changed? Has their income decreased? Do they have the same family size? Have any of those factors changed? That's different. So I'm not sure which one you're referring to. Is it? So a situation where the participant may have underreported income, we discovered it, we clawed the money back, and now they're responsible. Yeah,
So in most cases where there is underreported or unreported income, it's not taken from what we're currently paying right off top. So what we do is a repayment agreement analysis, determine what was either unreported or underreported. And then what we do is enter into a repayment agreement with that family. Now we will do a transaction to place the income in the system and then place the tenant in the right amount tenant portion. With that being said, because it was underreported or unreported, they do forfeit their 30-day notice. So if we caught it on the 15th of October and we made it effective November 1st, what we would then do is do a repayment agreement analysis for that family and enter into a repayment agreement. We will not take anything back from the owner at that particular time. Okay? Okay, so you can see us or see me after this, okay?
All right.
Yes, sir.
Seems like the tenant can pay over the amount that you approve in your HAP contract.
No. So if a HAP contract is allotted for 3,000 and the tenant is responsible for 2,100, the only thing the tenant can pay is 2,100. So we have an amendment notice that is mailed to the tenant as well as the owner. What is stated on that letter is all the tenant can pay. If they pay anything over the amount on that letter, they are in violation of their family obligation, and that is a reason to be terminated from the program.
Can I ask a quick question?
Hold on.
Up here?
Yes.
What happens if we approve the rent, but the tenant later comes in and report an income change, and now the unit is not affordable?
So we are going to talk about that a little bit in this session. However, once we do the rent determination, we don't do affordability again. Okay. So affordability is done at the initial stage. So it's only done one time. If the tenant income changes, that's a totally different topic. Okay. I think you had a question, and then we have two in the back and then one on the side. Yes, ma'am.
Also be held responsible for the late fee.
Yes, it's whatever is stated in your lease. So her question is the tenant responsible for any of the late fees when they pay late? And yes. Okay, I think I had this young lady in the black shirt. Yes. So going back to what Vincent stated when he said there's three parts in which we look at when we're trying to assess the affordability for the tenant. So whenever you turn in RTA, we do the owner eligibility and then we do the affordability. It's only done once. Then anything after that would be the tenant requesting an interim or the owner requesting a rent increase. Okay. So we're going to get to that a little bit later because that's in the questions. So I'm going to go over what a tenant can do when things change or their circumstances change in their unit or in their home. Okay. We had this question with the lady in the green. Yes.
The Chicago Housing Authority. As a resident and participant in the Chicago Housing Authority, looking to transition into the housing choice voucher program for the scatter sites for homes, because right now a lot of seniors are taking care of their grandkids, and the current like senior housing, which is like one bedroom, does not fit the need. So I just wanted to know, are the processes to add like grandkids and your great grandkids or your kids that's, you know, not in a position to pay on the lease? How do that work? Is the process still the same to qualify for a bigger property in multi-family generational housing?
It is typically the same for both scattered sites, PPV, and HCV. You would need to report that to your management site and then ask them what would be your next step. I believe in some scattered sites and PPVs, if the tenant has done their initial 12-month, they can request like HCV or a new unit because you have maybe been given custody or guardianship over minors. So you would just need to talk to your property manager.
Now, what about like for just taking care of your grandkids in the summer? Because I don't have custody, but I do want to be able to have space in a place for them to spend the summers with me because they're out of the country all over the place. So that was something I didn't know if you can add them to a lease if they're not your sole custody, or if you don't have sole custody. Okay.
No, you wouldn't be able to do that.
Okay, thank you.
Okay, and I think the one last question we would take is the gentleman with the black.
Sir. Who she requested an interim and she also requested a move at the same time. And for some odd reason, that move was requested before that interim, which left me with her not paying rent for the last 3 months. And I just want to know, is that standard process? Is that typical? Do you see that? Or is there anything I can do about that?
So sometimes we have to look at the nature of the request. So the interim came in and then the move request. Was it an abatement that was tied to the move request? I don't know. I'm just giving you scenarios. And so we look at that. See me after this. We could take your information and look at it because I'm sure it would be on a case by case based scenario.
Absolutely.
Okay.
Thank you.
All right, thank you, Sherry. All right, question 7. Is there an inspections checklist for property owners? Why do inspection results vary depending on the inspector?
Oh, we woke up on that one, huh? All right. So this is for my new owners. So I'll go through it that way, as if I'm speaking to a brand new owner. My class? Oh, that was his class. I'm not gonna point him out right now. I'll do that later. We'll talk about it. But so for my new owners and my old owners, there is no pre-check list. There isn't a list of things that we send out to pre-check. However, we do give you access to our HCV guidebook. So you can go to the cha.org and download that guidebook. That guidebook is, I will say, it contains a good 95% of our fail items. We are in the process of updating it again to give you guys a new one. But it right now contains about 95 to 97% of our fail items that we are looking for and the way that we look at them. In terms of a pre-checklist that'll help, on page 33 of the guidebook, there is what we call rent ready. That is very, very important nowadays, because nowadays some of this may happen to some owners in this building where my inspector has deemed your new move inspection is not rent ready and you have to start over. That means you are not completing page 33. Page 33 details what you need to do for us to complete an inspection and determine whether or not you're ready to move on to the next portion of it, be it a fail or a pass, and not rent ready. We don't want to do that. Now, in terms of why things fell differently, let's just be honest. All of us are human beings. I am going to see something different than Danielle, than John, than Vincent, or Sherry. So when I come out there, I may see something completely different depending on what angle I'm standing at. It should not vary in such a massive amount to where this inspector is failing me for this smoke detector not being 15 feet, but this other one is telling me it needs to go over here. That shouldn't be occurring. When those types of things happen, we do ask that you report it to us so we can look at those on the case by case basis. And sometimes those people need a little bit more training, which we will do. But it does, that's the situation where I have to ask for you to help us. But it we are site based. So we're only going to fail what we see. So if I don't see it, it didn't fail. So if I come out to an inspection, it can be the exact same unit. I may see something today that I do not see tomorrow just because my eyes are my eyes. She was one. Earl Miller. Yes. Yes. I will say this, 33% of our units pass on the first inspection. The first inspection that we actually get in, 33% of our units. There's some owners in here that may be able to talk about QC and how often they're QC, and it's because when we come to their unit, they pass on the first inspection. There we go. And we thank you. Red.
Quick question.
Red.
In
1
regards,
second, I'll come back.
in regards to inspections, inspectors used to give us a call 30 minutes or so when they're on the way to you. Now they will just show up. And so you have to get your maintenance guy over there so they can get them to the basement or other areas tenants cannot get them to. And unfortunately, we have failed because of that, not because of anything not being done. Is there a way that inspectors can be mandated to call the management or the number on file to give us a heads up so we can be prepared for you?
Well, we do that the day before. The day before, the day before, I give you a call and I tell you what the time frame is. I tell you I'm going to be there between 8 and 11. I tell you I'm going to be there between 9:30 and 12:30. I tell you I'm going to be there between 11 and 2. That inspector going out to that unit, he does not always have the time and ability to give you that phone call. The problem is with that is I could go to her unit and the tenant doesn't let me in. And I've told you I'll be there in 30 minutes. And now I'm there in 12. But the problem is we still don't get in because your maintenance man isn't there in 12 minutes. Your maintenance man is going to be there in 30 minutes because that's when I gave the call. I told you 10 minutes ago I'll be there in 30 minutes because I intended to do her inspection, but I can't get in. So that's why we can't mandate it. But we do try to do it as a courtesy. So you have to make sure you let us know the day before if there's a particular number you want us to call. In some instances, the number that's on file goes to a call center. It goes to a call center. And that call center, that inspector, Mr. Acuff, can't wait 5 minutes on the phone to get to that call center rep, to tell that call center rep, hey, because he has to stay on time frame, because she doesn't need that 30-minute call. She's sitting at that unit waiting. and I need to make sure that we stay on time. Now, I see we got a lot of questions for inspections. We will answer every question you got, but we're gonna save it to after. Okay, let us get through the pre-questions, and then we will answer those questions.
It was an excellent partnership when you would call us. We have over 100 units and I have maintenance guys all over. And so because we pass about 95% of the time, the 5% is because somebody did not call. And so it would make it easier on your staff, saving you money, coming back out to reevaluate something that would have been accessible if you just gave us a call. That's it. I'm asking for the partnership.
And I have no issue with you asking for that. However, I have to say this: we went from a point in time where I was giving 4-hour time frames. I broke it down to 3, which is better, which most owners in here ask for at older things that we've had. It is difficult for us to make that phone call and guarantee you that it's going to be 30 minutes before. It may be 5 minutes before. Here's the thing, and I'm just going to address this way. When my inspector gets to the unit, he's going to wait for 10 minutes. He's going to call. So if your maintenance person can be there in 5 minutes, he would make it there within that 10 minutes.
Be a conversation with all of the inspectors so that you have an SOP with that everyone follows, and I think that will make it better. It shouldn't be based off of one person to the next person.
Understood.
Yep.
All right. Thank you all. You have another person you want to? Okay. Oh, you had that gentleman.
And then the gentleman right here, not you, sir. Flag.
Yeah.
What I was going to say to the lady that asked the question was that, so I pass on the first time pretty much all the time now, but it's been a learning process. I didn't start off that way. So the first couple of years, I was lax. I just said, well, I know it's going to fail, so I'll just take the list, do what I got to do, and take it from there. But then once I started really getting more serious about, you know what, let me go check on the units a little bit more. Let me go, if I know I have an inspection, let me go do not just one pre-inspection, but 2 pre-inspections. So I know that, when they come out, I'll be okay. Now, like you said, you chose your words carefully. You have some good inspectors and you have some asshole inspectors. And some of them, they will take the time to say, okay, this is really minor. I'm looking at everything else. Just get it done. But then you have some, if your smoke detector's missing a battery, hey, I got the battery in my car. Let me go get it. No, I'm failing you right now. So that's where the discrepancy can come, as far as you got some that are good, but then you have some that are just like, I don't have 2 minutes for you to go and do X, Y, Z. Or, if I have a smoke detector that's not hanging properly, hey, I can go in the car, get a screwdriver. I can't wait for that. But you still have to check the rest of the unit. I'm just going to fail you right now. That's not right.
So allow me to say this, and I'm just going to say this to address that. That is something that we can discuss further. As they said earlier, if you have any suggestions, send it to the owner outreach so that we can get those. But what I must say to you, give me 1 second, sir. What I must say to you is to notify you that if you are doing it with my inspector and it's just you and the inspector, you can't leave. If you leave, they have to leave. So they can't let you go out the door. If they do, don't tell me, because they're not supposed to.
No. When I'm there,
You're not on.
when I'm there, my tenant is there also. So someone would be in that apartment. I mean, I'm used to it now, and it doesn't bother me because it's been a learning curve. But like I said, you do have some. I've had inspectors where when you all changed and you had to put the unit designator on the door, I didn't know that. I had one inspector say, well, you know what, just take some white out, put a number 1 on there. I'm like, that's tacky. But he saw that I had everything else done with the apartment and he didn't want to fail me for that. And I told him, just fail me because I'm not going to take some white out and make the outside of my apartment look tacky. So, you know, it's just a big discrepancy as far as all of the inspectors at least trying to be somewhat on the same page.
Understood. That's something we can talk about.
Okay, out of respect for everyone's time and everyone's question, we're gonna move on. The next question is, does CHA conduct pre-inspections?
This is question number 8. We do not,
Sorry.
yeah, that's 8.
I'm sorry.
That's 8.
Oh,
We
that's
do
it, yes.
not conduct pre-inspections or post-inspections. I'll just answer that for both of them. We do not come before you have submitted a RTA or moving papers for a new tenant, and we do not come after that tenant has vacated that unit.
And we can skip question 9 because Earl answered that about how much notice is given and will the inspector call me in advance? You indicated that you called the day before, correct, Mr. Miller?
That is correct.
All right. So question 10, what are my responsibilities during an inspection? Who's responsible for pest management in the unit?
All right. Okay. Both parties are responsible. However, we're going to hold the owner responsible for ensuring that the infestation is cleared. We're going to hold the tenant responsible for making sure that they do not do anything that adds to making that infestation grow or keeping that infestation there. So if that tenant has trash around the unit and things of that nature, we will fail that tenant for that portion to make sure that they keep a tidier unit. One thing that many of you may not know, but we do offer a weather-related extension, a non-weather-related extension, to give you an extra 30 days to clear that out, because many of us know that it takes more than 30 days to clear out an infestation. So that is something that we have instituted, but that does require, that's why you may have seen it on some of your files where it says proof of professional extermination. It does require that the person that did the extermination is certified in doing exterminations in order for you to get that extension. That can work as long as you have a full detailed plan. So like a Orkin that'll have a full, her question was, does a receipt work from a professional place? And as long as they have a detailed plan saying they came on this day and this is the next day.
Will a receipt work if you go down to the professional exterminator store?
So that's not
Have your
the,
property
that's
manager-
different. The person doing the extermination has to be certified.
Got it.
Not where you buy it. The person doing it.
The products. You can't
Understood.
get the same thing from Home Depot. I'm sorry.
I completely understand that. But you have to be certified in doing an extermination in order to get that extension. So if you're certified and you go and buy those products and you do it, you can get that extension because you can provide proof to us that you're certified. But you have to be certified in doing exterminations here in the state of Illinois.
Okay, got it. Thank you.
Let this be the last one so we
Can
can
I-
go ahead. Go ahead, sir.
Can I ask a question that's a little bit off, because just to let people also know, if you parked on the east side of this building, you know, you got to move that car by 4 o'clock, else you're going to get towed and ticket. So, you know, just to let you know that, and I'm getting ready to boogie from that. But I have a question that's off of the subject, if I may ask it, and that is, why, I'll give you my situation. I had a tenant who refused to pay their water bill. I contacted CHA, gave them paperwork, et cetera, and told them, and even came down here. Then the tenant had nerve enough to request a movement to move. CHA approved them moving after I had filed a complaint with CHA saying, help me with this person giving me my money for the water bill, which I had to pay, but it's in the lease that they're supposed to pay the water bill. So my question is, why does CHA reward a troubled tenant like that when you have informed CHA in writing and in person of the discrepancy prior to you approving a tenant moving, and then you approve their moving to another unit and you still supplement their rent?
So I know you want to boogie out. So
Yes.
if you would be so kind as to give Ms. Pearson your information, I'll call you tomorrow.
Okay,
Is that
thank
fair?
you.
So I won't know because I don't know what he submitted. Well, I would have to look into the matter because what tenants can move because we have the Violence Against Women and Men Act. If they say that they fear for their life or there is a problem, we can't stop them because Mr. Owner said they owe the water bill. That does not mean that they cannot be held accountable. So even if they're held accountable, you may not know that. As Mr. Acuff said, we don't call you and say, hey, we held them accountable. So that's why I wanted to look at his specific situation, just so I can see what happened and go a little further with you and we can discuss it. Okay, so if you give Ms. Pearson, I don't know what she wants, the lady in the blue jean jacket, can you get this information?
We got one more question here.
No, you're gonna call, well, I'm the director of owner service, so you can call owner service, or you can also email the owner outreach and we'll assist you. They'll route the call correctly, okay?
One
So
more
let's,
question
because we're
right here.
getting low on time. I don't know who's my
Yeah,
timekeeper.
I've been waiting an hour
Where
to
are
ask
you?
the
I can't see
question.
you. Oh, I
The
can't see you.
question is related to, do you all work in conjunction with the Cook County ordinance for notice that is for rent increase as well as for termination? That means that now they've changed to this stair step notice. So only if they're in there 6 months or less do you give a 30-day. If they're over 6 months, then you might have to give them a 60-day, or you might have to give them a 90-day, depending on how many years or whatever they've been in there. Do you all work in conjunction with that in terms of if they ask for moving papers? Do you make sure that there is a 60-day gap or a 90-day gap, or do you just honor it right away?
So currently, we review the tenant's eligibility to see if they're eligible to move. We also review what the reason is. If you're asking, if you're labeling them as a required move, you want your unit back or whatever the situation is. If they are determined to be eligible to move, then we will issue the moving papers. So we are not doing you've been here 6 months, because they're still in a lease. So it would have to be, everybody has a reason, but if, again, they fear for their life, if they have a domestic situation, if there is a reason why they need to vacate the unit prior to the lease ending, then we will review that situation. We will review what circumstance has brought them to that need. If it's after the lease and they're a requested move, they've lived in your unit 15 months and now they're not in a lease with you, they want to move, we review that and then they can get their moving papers. So we don't do a stair step here. We follow our procedures as it relates to move, and we just confirm that the tenant is eligible.
Though the county would require that, let's say after that 15 month, that they give notice for 60 days to move, you all are saying if they want to move and there is no current lease, then they can just move, right?
We give our tenants a notice to vacate. They're supposed to give you that notice and you sign it to say, yes, Mr. John can move or whatever. So, but sometimes they do, sometimes they don't. And, and we don't force that. So it could, but we do give that in our packet.
Notice to vacate.
They should. Well, what did you put in your lease? If your lease says that, you are the owner.
Right.
We provide subsidy for approved participants on our program. I think Mr. Acuff or something said that this is still your property. Oh no, it was Vincent. We don't manage the property. We don't enforce your lease. You do. So if you said in your lease, I'm going to evict you if you vacate without notice or whatever, that's your lease. So we can't supersede that.
Can our lease dates do they have to coordinate with their initial move-in contract and everything with you?
Yes, the
For
first,
for all the renewals subsequent, all the dates have to be, like if they moved in March originally, what I'm saying, and then next March, let's say if you did not give them the lease, and by the time you went through the terminations with you all for a rent increase and everything, that comes maybe 3 months later. And do you make your lease date to reflect the 3 months later, or do you have to go back to March?
so the second year lease, we don't mind. That's between you and the participant.
Okay.
The initial lease has to match our HAP contract. Right, because you don't have, they could live there month to month if that's what you all agree upon. Okay. All right. So okay, let's see. All right. What is the timeline for a rent increase request?
Okay, so during the initial term of the lease, which is generally 12 months, but could be longer, you are locked into that rent for that initial term. Subsequent to the initial term, you can request a rent increase. But the CHA does follow, as far as the notice that we give for the rent increase, the local ordinance, and the effective date of the rent increase is determined by the length of tenancy in which the person has resided in the unit. If the person has been in the unit for less than 3 years, you have to follow the HUD guideline, which is at least giving us 60 days notice before the rent increase can go into effect. So that's the HUD regulation, and if it's been less than 3 years, that local ordinance doesn't kick in. However, if the tenant has resided in the unit for more than 3 years, then you have to give 120-day notice of the rent increase in accordance with the local Chicago ordinance here. So that's a requirement that we follow because we have our federal law, which has 60 days, but our city law that's 120 based on that. The determination for rent will be similar to what was alluded to before. We're going to look at the lower of the requested rent and the comps. But what was also mentioned before is that in the initial rent determination, there is an affordability factor. That affordability factor does not come into play with the rent increase. So keep in mind, you may have a rent increase where maybe the market will support the new rent amount, but if that rent amount goes above the CHA's payment standard, which is the maximum amount that we will pay, the tenant portion that they pay maybe a little bit more than 30% of their income, maybe 40%, could be a lot if you go over it. Let me finish and then we'll get to questions because I still have some more things. So that's something to keep in mind. Sometimes the landlord will go, okay, my rent is, the market has changed, but depending upon the tenant's income and depending upon their maximum subsidy that we can pay, it may create a rent burden for them, and then they may request to move. So the CHA will evaluate units, like we said before, unsubsidized comps, and determine whether the rent amount that requested is equal to and matches the requested rent. If it does, we will approve it. If it's a partial match, you may receive a reduced offer. CHA may deny a rent increase if there's any outstanding HQS fails. If there's an abatement, those issues have to be cured before the rent increase will go into effect. Once the rent increase is approved, we will send the tenant a letter, and you all a letter with the new rent amount, with the tenant's new portion, and the effective date of that rent increase. And again, the effective date is contingent upon the length of tenancy. So that's the rent increase process. You've been patiently had your hands up. Go ahead.
My question is, most of the questions that are posed or are for HCV. I am a PBV property manager, and it's a little different when doing a rent increase. For instance, I can do the small area FMR for my zip code, and I can go with the floor amount of how much the market rent would be. And then I would guess would include the amenities that are provided within the property. Many of my tenants are zero income, and I'm still not allotted the amount. So it's kind of like I'm, as a property owner, I'm getting the short end of the stick. Can you explain how PBV rent increases are established because we're not doing it for an individual. 9 times out of 10, it's for an entire building.
Yeah, PBVs is a little different. The rent increase takes place on the anniversary, and it'll be, the rents are all determined for the building. I actually haven't done that function in a minute. I don't handle that function here. My understanding is it's similar to HCV. It's looking at it's the comp, but it also looks at the percentage of the fair market rent, and which is an average for rent and utilities in the locality, and looks at the smaller of the two. So why a particular rent was not approved or denied, I can't speak to for that. With PBB though, the rent amount is based on 30% of income. So the tenant's income does not impact the rent approved amount. So I'm not sure why those rents were not, maybe that we could look into that particular case at the conclusion, but it's not based on their income.
And I'm going to ask one more question because it's, like I said, most of the questions are related to HCV. If possible, just a suggestion that you can have something like this for PBV owners or only to
Sure.
answer our questions. So that way we can get some clarity because a lot of this stuff does not apply to me. However, I would like some answers. And then as far as like the other young lady alluded to, when it comes to tenanting, getting tenants, the response time, because our buildings are operated off wait lists that are provided by CHA. Some of the wait lists are outdated. A lot of them, if you have a criteria for your building, individuals that are looking for housing just check anything. We need a system that will pull directly into what we are servicing versus getting a list of people who we don't even qualify for our particular building. So, and then when we do get someone, the turnaround time to get these individuals housed is astronomical. I have waited 3 months for one unit. And then it goes, a lot of different factors come into that because we have contracts with different funding sources and we become non-compliant, but we aren't, it's not our fault.
Understood. I think the owner services would, take that feedback under consideration and maybe work on some best practices for PBB as well. Because yes, this is mostly HCV. So.
All right, John, I hate to interrupt, but we're almost at the 4 o'clock hour and we want to get through these slides. So let's move on. All right. Who pays for the rent increase amount, CHA or the participant? You answered that, right? Okay, thanks, John. What happens if my tenant loses their job and can't afford rent?
So it's imperative that the tenant reports the decrease in income immediately. We have seen oftentimes where the tenant just doesn't come and report it to our office. And with that being said, they're trying to pay the rent but don't have the monies. Ultimately, what's going to happen is they're not going to be able to pay their tenant portion. Again, it is the burden for the tenant to come report any changes to their servicing office immediately. Yes, ma'am.
Everyone can hear it. Excuse me. How soon after the tenant reports it does it go into effect?
So if they report it before the end of the month, the last day of the month, it's made effective for the very first of the next month.
And if it isn't, and you know they reported it?
So in most times it takes about 30 to 45 days. Please understand when a tenant reports a change, it is their burden to provide the documentation that shows that they no longer have that income. Whether it be a separation letter or 2 current check stubs, a lot of times they are not giving us the information that we need in order to process the transactions.
Just to reiterate what she's saying is reporting it isn't calling and telling us. It's not coming down and saying, hey, I no longer have this income. They have to submit documentation. It's not complete until that documentation is submitted. Once we have all of that documentation, that's the date. of you reporting it.
Yes.
And it's the first of the month following that.
Also, they can use the online portal, which is the Rent Cafe. Again, it is their burden to upload the documentation to support the changes. If we don't have the supporting documentation, most likely we will deny the interim.
All right. So let's move forward. The next question is, you answered this? Oh, okay. Thank you. No, I'm there. Is there a list of CHA contacts for property owners to reach out to?
I think you answered that at the beginning. It's the owner's email and I think the address for the owner services, 60 East Van Buren, in Chicago, 60605. And do you have any other?
Owner, ownerinfo.org. Yeah.
We also have the owner outreach team for property. Sorry about that. We also have the owner outreach team. We will raise our hands up here. We are, Emilio, we are the owner outreach team. So if you have any questions relating to the HCV program, see Emilio. Okay.
Thank you, Shannon. Okay. So, what? It's out of order. Okay. Did I miss it? Sorry, small technical difficulties. Okay, here we are. Is there a way for property owners to target HCV tenants who are looking for housing?
No, unfortunately, voucher holders will approach you if they're interested in renting your available unit. That being said, HCV property owners are encouraged to market their units to HCV program participants as they would to any free market tenant. Examples include using online listings on apartments.com or affordablehousing.com, placing signage on or around the unit, or also using advertising apartment guides. Furthermore, if you're interested in becoming a landlord partner with the CHA, we recommend that you visit the landlord page on CHA's website. From there, you could attend an on-demand briefing. There's a lot of other good information. This question specifically about advertising to a potential tenant, but you might find yourself in a maybe you're acquiring new properties and you've acquired a building that has multiple pre-existing HCV residents. That's another way that you could potentially acquire more participants, and that will give you a step-by-step guide on how to navigate that process.
Thank you. Well, we've come to the best part. Questions. See? All right. Okay. Okay.
I guess my question is in the vein of recapture rent. In a situation when you end up in a month-to-month, you ask for a rent increase. You passed an inspection before the annual term, and then the rent increase is now effective 3-4 months later. How do you ever recapture the 4 months when something like that happens? And the second question is, once the rent increase goes in a month-to-month in a traditional situation, you could change the rent in a couple of months or 3 months. But I would think that in your case, I think I read in the letter I got that I'm now locked into that rent increase for the next 12 months, even though on the market, I could change it on a month-to-month situation with just notice.
So I think you answered.
So the CHA does have a policy that we don't allow a rent increase to occur more than once a year. So as far as depending on the length of the tenancy and the effective date, the old rent amount and the old portion would cover the period prior to the effective date.
I just said I didn't recapture that.
There's no recapture for that. We pay the tenant would pay their portion, we would pay the new rent, and we would give notice of the rent increase based on the effective date.
Yeah, so March, April, May, June. That's 4 months I didn't get the increase amount. Now I'm locked in, like you said, from June all the way to the next June, even though the next annual is in February.
I don't make the rules. I'm sorry.
I'm just saying.
Hi, I have a question.
I received a letter from you all that my tenant's, her portion is going to change. It's going to be increased with what she pays. I plan on doing a rent increase on her. I don't know that she can afford, because her rent, the increase from you all went up. Will you all do something as far as that? If I'm asking for a rent increase, will hers go down, or how does that work?
Unfortunately, not necessarily. So we may have did an annual recertification or interim for that family that increased their tenant portion. If you ask for a rent increase, we can't solely say who's going to take the increase. It could be the housing authority, it could be the family. It solely depends on their income and what we're paying. Now, please understand what John was saying. If your rent increase goes over the amount that's allotted, then the tenant will pick up all of that. So if we can only afford to, if the maximum we will pay is 2,600 and you're asking for 2,800, they're already paying 13. They're gonna pay that $200 that's over the maximum amount. So they will pick up that entire increase.
Just to add to that really quick, when a participant undergoes an annual recertification, they'll increase the subsidy that they're eligible for, also known as the payment standard. CHA will set these on an annual basis. They're based upon what are called fair market rents that are set annually by HUD. They're able to pick a payment standard anywhere from 90 to 120, 110% of what that FMR is. And so you might find instances where the subsidy bumped up, that is the payment standard, right before the rent increase request. In that context, it's possible that CHA would actually pay the full portion of the increase. Alternatively, you might have a bump up in the subsidy because it hasn't been applied yet and you are requesting the rent increase. It's actually CHA's policy that if a family's undergoing a rent increase, they'll increase the payment standard amount if they haven't had it already applied for them.
Okay, I'll be right here.
My question, in the last 6 months or so, there have been more possible tenants coming to look with people that they don't even seem to know, like maybe a tenant match situation. And sometimes one or the other of the tenants will have children. So it's kind of a blended situation where it's not family. How's that received by CHA?
I'm not aware of that.
If there'd be two adults applying, potentially don't even know each other, they're tenant matches, and I assume it's because of the lack of availability of units and the escalation of rents, and people are just having to do that to live with people they don't even know. So how would that be handled?
I don't know.
Do you,
Have you seen that before?
I mean, typically when people come onto the program, they declare who their family is. And there's a definition of family in our administrative plan. The definition is a little bit looser at eligibility because it's kind of thought this is who I live with, and and the definition gets a little bit stricter when it comes to adding people to the voucher, because sometimes when people try to add people to the voucher, it circumvents the waiting list process. So look in the administrative plan for the definition of family, and that defines who can live together at admission, as well as who can be added to the voucher based on that definition.
My question is about pest, bed bugs infestation. My tenant gave me a call and told me that they have bed bugs and they brought it to the unit, and they even showed me a picture. And so whose responsibility is this? What I did is they said that we want to take care of this one, but but they didn't say. So I said, okay, I will submit my telephone. So anyway, what I did is they wanted Orkin exterminator. So I said, to make easy for them and for me, I asked them whether they can split the the expense. So is that fair, or do I have to take all the $600 to pay the Orkins for the bed bugs, treatment?
You are responsible for making sure that that bed bug infestation
Even though
is clear.
they brought the bed
Even though
bugs?
they brought it,
Oh,
you are
okay.
responsible.
Well, but-
Even though they admittedly brought it, you're
Yeah,
still
they-
responsible.
Well, I thought it was fair that
The
I
program,
split it.
the program requirements require that all infestation, it's a part of HQS. HQS states that all infestation will fall under the owner. There is no if, and, or but. It's a must. So that is a rule that we must adhere to. It's not up for debate amongst us. Eh, We will talk out right after this. I'll show you where.
It's obvious all kind of repairs damage caused by the tenant, but still owner become a responsibility. Don't you think that's stupid?
It's going to be based on wear and tear and what we believe occurred. It's going to be based on wear and tear and what we believe occurred and how long we've been at the unit. It's something that we have to be able to prove, but I don't want to.
So we only have 2 minutes remaining.
So
I have the question here. I have the question. What's the chance, there's the rumor on internet that government wanna put the 2 years limit for CHA tenants? Is any chance it's gonna be approved, or what's your opinion about that?
I didn't hear the question. Can you repeat? I'm sorry.
The Trump administration gonna propose that gonna be 2 year limit for Section 8 tenants. So they're gonna be limited only for 2 years. Is that true, or it just?
that's up to this administration and between them and Congress. That doesn't come from us. We administer the program once we receive it. That's a decision that has to be made in DC.
But it's gonna be like for our state can protect themselves, that you can do something about that, or
We can do nothing about what DC tells us we have to do. So that's going to be decided in DC. And once that's decided, then we will inform you guys based on any type of changes that may happen at that time. Give me 1 second, sir, because we are about to run out of time. So let me see you, that corner.
Okay, as long as I can ask a question.
You need to see him too? Okay.
Yeah, I mean, oh, okay.
Go ahead.
A quick question. When it comes
Yes, sir.
When it comes to quality control inspections, right?
Yes, sir.
'Cause for a while, I was getting hit with every inspection. I got a QC inspection afterwards. But when we talk about lead and we talk about kids under 6, there's a different type of inspection. But once they move in the unit, they're moving furniture through hallways, they're moving furniture throughout their units. And when you have a quality control inspection that comes out with a kid under 6, half of the time you're failed, not because of anything that I've done or that we've done, is that the tenant just moved into the unit, right? So then they're bumping walls, chipping paint, and then we fail and have to paint again. Like, can something change when it comes to that?
So that's a very long question, but I'll give the quick short answer. Quick short answer is that lead is encapsulated within the wall based on the paint that you use today. The worry isn't the paint that you use today. The worry is the paint that they used prior to. So when you paint that new latex paint keeps the lead in. Once that lead paint becomes deteriorated, it allows lead dust and lead things to come out of that wall. That's why you have to keep it painted.
Right, but we're talking about
That's why I said it's a long question, because you're gonna have a retort for what I said.
But we're talking about a quality control inspection. The unit was just painted. The hallways were just painted. The tenant moved in. The day that they moved in, after it was just painted,
Understood.
and just passed inspection, they chipped the
I'm following what you're saying now. So you're saying that the next quality control is still a fail item.
Absolutely.
Because when we come out to the unit and we see the unit, they were allowed to move in. The paint was scratched up. It was deteriorated. It is in your best interest, because some of the things we do in your best interest, which is making sure that that paint is encapsulated, because you don't know, I assume, you don't know whether or not that unit contains lead. So in that situation, you want to make sure you go ahead and paint. That's one of the major reasons we still go ahead and fail you.
You mean paint again?
Paint it again. You are correct. Again, for a second time.
All right.
Okay, this question-
My second question is, when it comes to, for example, so I had a unit pass inspection. The tenant didn't work out, but the unit passed inspection. I got another tenant right after that that applied for the unit. How long is that inspection good for, and does it include weekends?
It doesn't include weekends.
No,
Good job.
I mean, like, I know.
Good job.
30
No.
days, 30
I'm gonna
days.
no. It is 30 calendar days, not business days. So it does not include weekends. It's 30 calendar days. So you don't get extra days just because the 30th day falls on the weekend. Okay? It's 30 calendar days. That's all the time you have to resubmit. And the family structure has to be the same or higher on that previous tenant.
This question is very quick and simple. Are you okay? Oh. Okay, the payment standard guideline, which increases every year, is hard to find. Can you tell me where it's going to be? Because it seems like it moves around and we can't find it on the CHA.org site. So that payment standard guideline, can you tell us where we can find that every year as it increases?
I thought it was on the website, but it does change depending upon whether or not they live in an opportunity area or a non-opportunity area. So opportunity areas are areas where they typically are, there's mobility, the mobility area, which meets that criteria. The payment standard is higher for the mobility areas than for the non-mobility areas. So, yeah. Okay.
Can you note out standard payment guidelines right here?
Do we have that on any owner services or in the owner? Okay, all right. We'll work on that. Sure.
Thank you. And thank you for all of your services that you provide.
Thank you.
All right, thank you all. This concludes the HCV program town hall. If you're interested in property owner resources such as webinars, newsletters, guides, tutorials, and more, scan the QR code on your screen now. Thank you. Her lease or tenancy in your unit. Okay.
So she had moving papers. However, the lease, she was breaking my lease. So the lease would have ended, let's say, in June, and she requested to move in May.